Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy. The dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case. Dati mihi Anglican priest, Verbus Latino.
That's literally not true.
Is that correct?
Oh, for Trump's sake. I didn't ask you to interrupt me.
Good morning, welcome to the Court of Public Opinion. Happy Monday to you. I am the Recovery Addict. It is a wonderful Monday. Excited to have a brand new week ahead of us and a lot of fun on the schedule. A little bit of a holiday today, though. Let's see. Happy Thanksgiving to Canada. Yes. Let's start with this before I forget. Kim, congratulations. Welcome, Kim. Kim, our first in chat today. Kim, you know what's coming. You're being sentenced to internet ownership. Everything IP-related worldwide is your responsibility because you were so prompt, so eager to get this morning started. You were first in chat, and we are punishing you accordingly. You're going to do great, Kim, as you always do. Seats are not working. I knew it. It's like the warm-up this morning was just too quick. I'm like, I missed something. But we'll get the seats fixed here in just a second. Hold, please. How was your weekend, everybody? Brewers won. That was good. I think they only played on, Saturday night or Friday night? I think it was Saturday night. Let's see. No, I don't want to update right now. There we go. Seats should be working.
Have them send someone with more experience.
Thank you, sir. You're my new best friend.
Right, there we go. All right. I think we're done now. I think we're good. And chat's back on screen. What more could you ask for, right? Nothing, I tell you. Wow, let's see. Good morning. Welcome. How was your weekend? I think we covered that part.
I saw a chicken fight.
Happy birthday. You look good.
We do have to do birthdays in just a second. Why am I so tall? I'm doing the T-shirt today because it's sort of a holiday. We'll let the birthday messages come in here over a little bit of time, but let's. I'm going to tell you why we had to start late this morning. Not late. I was on time for when I said I was going to start, but why when I said I was going to start was later than it normally would be. Yes, a squirrel. I kid you not, a squirrel.
I don't like podiums, Your Honor.
There's a squirrel in our house, and I like squirrels. We feed the squirrels. We enjoy watching the squirrels. Kiki eats the squirrels. Everything about squirrels is usually pretty good with us in our house, but not when they're in our house. So this one was the first thing my son saw when he woke up this morning was a squirrel in his room going, what's up? And that's
a video of roaches fighting. I don't know who won.
That's not okay. The squirrel in the house is not okay. I love wildlife, but if the squirrel decides to nest in the house, it's going to be fight to the death. And I usually win these fights. As a matter of fact, I can't think of one that I've lost with a squirrel. We've had a couple times. But last draw was when there was one in my old garage, which was converted into an Airbnb. Ended up just about killing me, but then it ran away and I didn't kill it and everything was fine. But squirrel in the house, we're going to have to see how this one ends up. It might be the last place it decides to be ever. So there's that. Yeah, squirrel. It's the air got colder is what happened. It's your fault. I saw the broadcast the other day when you were talking about wildlife. 100%. Yeah, that's exactly what we're going to do. I would employ my Red Ryder BB gun from, the Christmas Story. You'll shoot your eye out, that whole thing. That's what I would use, which is not powerful enough to kill the squirrel, but it might convince it to leave. And if that doesn't work, if we get a good stinger on it, which is what it does, it just, then I do have a stronger option that is still considered an air rifle. So, and that would finish it. Anyway, the squirrel's where you got the rancid nuts. Yes, so we're sort of, he's already fired the shot over the bow, but they'll come. Oh, I know. The one in the garage did. It just about got me. It was running like circles around on the walls of the garage and jumped out. And I barely moved out of the way before it. It was like Superman at my throat is what it did. I barely dodged it in time. But give Kitty a chance. Here's the problem. Kitty is not an indoor kitty. Kitty did kill a squirrel last week and ate it, but not this squirrel, obviously, because it was in the house today. So I'm not against going up in the attic and setting up a lawn chair and a fan because it's hot always in the attic. Ivan, oh my goodness. Go Brewers. What an amazing win. 5 games, went to 5 games just to make it, just to drag out the suspense of the inevitable, but they did win. Sorry, Cubs fans. You knew this was happening. We're cheering for the Brewers here. Now that your Cubs have lost, join the winning team, and let's cheer for the Brewers all the way. That would be awesome. All right. We're celebrating Laura and Maddie today. Happy birthday. Okay, there we go. There's our birthdays. Let's go ahead and do the birthday song, and then we'll get started with everything else we have this morning. My glasses. That's what I'm missing. And I have a funny story. Don't let me forget to tell you a funny story about going to church. So here we go. Birthday song goes like this. Everyone stand up, take a breath, shoulders back, project your voice to the back of the room, blend your voice with your neighbor, and warm up with me if you will. La 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 la. Here we go. Happy birthday to you. Happy birthday to you. Happy birthday, dear Laura and Maddie. Happy birthday to you. Red has a motion to file after the birthday song. All right, we'll do that. We just had 2 people to sing to, so it's pretty quick. Laura and Maddie, happy birthday. I realize there are many wonderful days. Today is your special day. And I realize there are a million places you could have been, and a million people you could have celebrated with, but you chose to be here with us. The privilege, the pleasure, the honor, the joy is ours. Hopefully we can turn some of that joy back to you, make your day a little more special. Begin by helping yourself to free pancakes at Denny's, IHOP, Village Inn, Waffle House, McDonald's, Tammy Dunlap's House, Annie's Grill, Bob Evans, and Cracker Barrel. I think Recovery Addict should have to sing happy birthday in a new language every week. Ivan, I can't even say hello in a new language. Wait again. Konnichiwa. There we go. Japanese. Konnichiwa. That's today. You seriously overestimate my talents, Ivan. Add Kevin to the list. Add Kevin to the list. Okay, we're going to sing to Kevin on this next verse. Here we go. Happy birthday to you. Happy birthday to you. Happy birthday, dear Kevin. Happy birthday to you. No, we're not to the birthday. We're not to the drum solo yet, I don't think, right? We've got a while. Get your drumsticks out, y'all. Here's the cue. There it is. All right. Now you can join us on the drumsticks, the big solo. You're welcome. Happy birthday, Kevin. Beautiful. All right, Red has a proposal or a motion to file. I have to tell you a story. Let me tell you the story first. Please deny Red's motion. Did it come from Greeners? Like, was Greeners the source of this motion? Because I know he tried to get Amber to file one about a court case, which we definitely can't watch. I've seen the proof, Greeners. It's in mod chat. Josh is anti-motion. Josh had a rough weekend. I think he's going to be anti-anything right now. Let's see. All right, that's not it. All right. Oh, it's a big motion. Okay. Oh, I'm still scrolling back. I'm reading it backwards. Let's go back to... There's Josh telling us about his weekend. I won't read that part. Adelson does have a hearing at 3. Okay, hang on. Wait. Try not to tell you what happens in mod chat, but I still have to see what happens in mod chat. There's like 700 messages from this morning. Looking for red. I see you guys talking about something, but I can't see what it is. I give up. I can't read that much. Send it again. There's 700 conversations going on about everything else in my chat, and I don't know what you said. So, motion might be denied by default if I can't find it. Let's see. Let me tell you this. Let me tell you my story really quickly about going to church. I voted. I didn't comb my hair this morning. If you didn't see, I sort of ran my fingers through it, and it was good. I determined to shave off the goatee. I did. I voted. I voted amongst myself and said it's got to go. It's too long. It's starting to get a little frustrating. And Donna's sentence is at 3:00 today, this afternoon. It's after lunch. It's got to go. And I like announced it to the house. I'm like, Jen, my wife's name's Jen. Jen, it's coming off today. I'm losing the goatee. It's coming off as I'm marching to the bathroom. Like, this is my resolve. And I go in and I'm looking at it, like doing a little like how long is it measuring thing, it's the longest it's ever been. I've never had it this long. So this is a personal record for me. And I go in and I'm like, okay, so here's the idea. Because my son from his bed where he hears me announce this, he's like, make a lot of different like styles. Like he wants me to shave and have like the different types of looks you can make as you slowly dwindle away to nothing. I'm like, no, the only way I can do this is start left and just work my way across the face and just get rid of everything just all at once. And you guys know how this story ends because you can see me. So I start and I shave and I start up here and I work down, do a little bit of start at the sideburn, the bottom of the sideburn, work my way down a little bit of the beard and work my way down to the edge of the goatee. And I do the little, pull the goatee over and just trim up the edge a little bit, and then the bottom around the neck. And I'm like, I just can't do it. I just can't get myself to go zoom across the goatee, and I can't. And so I'm like, I trim up the top lip a little bit and just square it all up and looks nice. I'm like, that is all I can do. I thought I had it in me to get rid of this, and I don't yet. And so there, I trimmed it up, and it was like, that's it. I'm done. And I go to church. I'm like, it's going to be on for another week. And in the bathroom, church, washing my hands, and I look up in the mirror, and I notice I shaved my face like all this to right here, to right there. And over here had like 3 days growth, full on, never seen a razor in half a week going on. I had stopped halfway across my face. It's so every time I'm talking to somebody, I try to keep the same side showing. It doesn't matter which side it is, right? As long as they only see one side. I mean, I'm sort of giving them the slant eye. It looks good. It looks fine. But as soon as I turn sideways, you get this sort of like People do this. You know when they notice, right? And nobody mentioned it. Nobody said a thing. Honestly, Mrs. Ari didn't even notice. But I confessed to her. And, yeah. So there was that. That happened this weekend. All right, so let's see. Red pen, let's see. I don't know if Josh's post was Red Pen's motion, or if I'm so lost. I don't know what the moderators want. All right, a couple of people we have to mention as they have achieved greatness today. Lainey Sue, member for 8 months. I'm kind of introverted, so I don't chat much, but I love lurking. Been watching since Maya. Love y'all. That makes you an OG. Lainey Sue, thank you very much for your support. PJ Wolf Weemers, member for 25 months. Another OG. Thank you very much. Love the smiley faces. I am happy this morning. Selena K, member for 30 months as an attorney. Selena, massive supporter of the channel, and for, as you can see, 30 months. We're approaching the 3-year mark, Selena. That is just amazing. Just love every minute of the last 30 months with you all. Have a great day. Love you. Thank you very much. Laura Fry, member for 15 months. Woohoo! Love it here, Laura. Thank you. Thank you so much. I think you're an OG as well. OG! I think that number does not accurately reflect how long you've been with us. Queen Olive Ruth Ann, member for 33 months. Thank you, Queen Olive. True OG. OG. And Rose with Thorns, member for 14 months. With just a simple howdy and a bug. Thanks. Howdy with a bug. Thank you very much, Rose with Thorns. Appreciate you as well. All right. I think most of you have been here longer than your membership number might indicate. Let's see. Josh says, I'm glad Recovery Addict can't figure out the motion. Let's see. So I see something about that was Red Pen. Okay, let me read it. Josh says this was Red Pen's motion. Oh, the mods say open up the burner phone for calls. And let's see, we have so much content amassed. I've always wanted to pitch the idea of a rewatch of some of the fun moments, especially for the newer chatters. The bus video, the dog biting him, things like that. Ooh. I like the burner phone. The older content thing, most of the fun moments we've had with police chases and things like that, all got strikes, got copyright or got claims, which means showing them again opens us up to either another claim or a strike. If the person says, "Oh, this person's used it before," and they're using it again, that's the only issue. Is it basically just presents a whole bunch of possibilities for the channel to get a blammy, and there is also an issue with having too many copyright claims on a channel, where YouTube will eventually say, "Look, just get your own stuff," and sort of hit the channel with the ineffective strike. So that's why I don't go back and re-show a lot of things that way. My cat just jumped on the keyboard and highlighted this entire chat roll. That's amazing. The cat is invested in this conversation. Patty, been here unofficially since Maya. You're the best. Thank you very much, Patty. Welcome, OG. Good to have you here. Laura Thompson, good morning. I lurk from time to time. I don't remember if it was during Cavalcante or if it was during the Gabby Petito. I found you. Probably Cavalcante. And I say that only because that's where we had the most people ever at one time join us. It was crazy. Keep the goatee until Movember and then shave it for cancer. I don't know how the shave it for cancer part works. Like, I'm all for supporting a great cause like that, but I don't know how that supports the cause. Here's my complaint. I always thought I was a good eater, but the larger my goatee gets, the more it gets in the way of my food as it's trying to get into my mouth, and the more is left over on my face after I'm done eating. I've discovered I can't do pancakes because syrup is a pain in the butt to wash out of a goatee. So there's just a point where I put my response in mod chat and specific instructions in capital letters. Okay, thank you. Thank you, Josh. My response. Don't read out loud. Oh, okay, sorry. Okay. Got it. I didn't read it out loud. You don't have a goatee bib? I didn't know a goatee bib existed. Isn't it basically just like a balaclava? I mean, what would you wear to protect? And then balaclava has to be like disposable. So I just say his mustache was straining his soup. It does, but when I start eating and like mustaches going in the mouth as well, it's not as fun. It loses its mystery at that point. Face mask for your chin. Cream cheese is the best and absolute worst all at the same time. Does No Shave November just relate to our faces? Arms and legs also apply, Ivan. That's it. Arms, legs, back. That's as far as we're going. We plan to see Adelson this afternoon. Okay, you get pledges like a bike-a-thon, and then once you collect on all pledges, you donate the money to cancer. Barb, I like this idea, but let me tell you the biggest issue I have with collecting pledges on a channel. If someone makes a super chat and says, "Hey, here's to the No Shave November," YouTube takes a third. The taxman takes a third. And then I still feel obligated to donate the full amount that was given. Otherwise, when I go to donate to the cause, everyone's like, "Whoa, you received this much, and you only donated a small portion of it." It's very problematic to have me as a middleman for a donation. So I'd love Venmo would fix that. It would get rid of the YouTube portion, and then it would just have me. I still have to pay taxes on everything that comes in, and then so it just gets a third back to it. The easiest way is for you guys to donate directly. That way, it cuts me out of the middle. It goes to a good cause. I don't have any, heartache trying to figure out making sure that everything that was donated for a specific cause goes there. That's the easiest way. But I'm all for supporting a wonderful cause like that. You can Google Movember and it will walk you through it. I might do that. The government's shut down, so you don't have to pay the tax. Greeners. I know that's not the way it works. But the mullet is flowing fabulously. That's wonderful. Can chat collect the money on here? What we'd probably do? Let me figure out if there's a way I can get a link that can be donated to without it coming to me. Okay, that's what I would prefer. Something that you could see. That if you want the visibility, either anonymously or otherwise, that a donation came in, and that it all goes to the cause that's fighting cancer or something like that, but that doesn't run through my bank accounts, because then the government just takes a third. They don't care that it's for a good cause, right? They don't. You can't go to the IRS at the end of the year and say, "Oh, but these donations were for a charity." They're like, pay up. They're not fun. But pledge or donate. To some people, it's the same thing. Barb, it might be a great idea. It might be a wonderful idea, and we might actually do it. I just need to do a little research there to make sure it's something we can do. Got quite an education running on a 501c3 pair of halfway houses. Nonprofit policy is wild. Yeah. Donate in the name of Recovery Addict if you want to honor the channel. Oh, thank you, but honestly, I would use your own name or do it anonymously, or do it in the name of a loved one who is either fighting or lost the fight to cancer. I've got great news, because a good friend of mine, close friend of mine, just this last week announced that he was cancer-free. That his first screen after his treatment, after his third round of treatment, came back, and he came back clean. And so it's just awesome. It is just so exciting. But Red Pen member for 33 months. Josh just doesn't like my ideas. I love that everyone feels comfortable enough that they can share their ideas on the channel. But motion for RA to grow a mullet, that would take a lot of donations, and they wouldn't be going to anyone but me. I'm just saying, if I'm wearing a mullet, it's going to have to be worth my while. Red Pen, you're an OG, but you knew that. Thank you very much for your support. Great moderator as well. Cody Height, member for 5 months. A goatee beard is a bib. But then it's, yeah. How do I wash the bib is the thing. Snoozy Girl, Ian's fundraiser is a great option. I love what he does for the Children's Hospital. It's great. Glad we got to help a little bit last year. I think we helped for 2 years in a row. But got to make it. I did not, when I helped Ian the first year and the second, I did not understand what he goes through to make that possible. Like the back end after the fact, not just during and before, but the after the fact, what logistical nightmare he has to go through, sending everything out and moving things and making sure everything gets where it's supposed to be. That is just a burden. I don't want to add a single bit to his plate that way. If we can help some way where it does not add anything to him, as far as, something he has to mail out or monitor or, forward or something, that's what we do. Just a friendly piece of advice. Remember to submit the extortion and pay your taxes. Turns out they pay people to keep track of that. That whole IRS thing. Let's see. I vote for the mullet, RA. I'm not sure if it grows in well enough to have a mullet. I'm at the stage in life where a thick, full head of hair is something that I should cherish in the few days that I still have it. Life advice from Greeners is life advice versus life advice from Ivan. I happen to know, I'm not going to add, I happen to know Ivan has had some very good advice lately. He's had some recommendations that were good. Remember when RA wore a judicial wig for us? Yes, that won't happen again. Thanks for bringing that up. It was a mullet on steroids. It was amazing. I want to see Ian wear the wig again. I think we've seen a couple videos with him with the wig on, right? Mullets make you 25% more likely to find a beat-up Camaro in your front yard. That would be if I would ever mow it, right? All right. I have photos, yes. Texas, no worries about the misspelling. I have trouble reading, so between your trouble spelling and my trouble reading, together we'll get to the end. I love chat with both Ivan, Victor, and Greeners both here. That makes it great. Defense Rest, welcome. I'd be down for helping Runkle. Let me know what I can do. I would reach out to his mods ahead of time, probably well ahead of time. I think a lot of the problem that comes with that came to Ian is that a lot of us stepped in at the last minute. I'm not talking the main players, but some of us on the fringes literally just showed up at the last minute and said, "Oh, and I've got this to add to it," and they've already got a system and a in place to track it, and it added a whole bunch of workload that I didn't realize I was doing. So I feel really bad about that. Have we got anything trial planned for today? There's a possibility of looking at one. There's something about beating with a hammer. Like beating somebody to death with a hammer. I'm not sure exactly what that story is. A couple small courts are in session as well, but many of them are not because of Columbus Day. Our lawyers in our court still wear the robes and the wigs. I think it's great. I like it. Was the other case against the lady finished? Angelique, are you talking about the Link? You're talking about Daisy Link? Lady who got pregnant in jail through the air vent, because that's not done. As a matter of fact, we're right at the point where the state is about to arrest first thing tomorrow, but they're taking today off. Hannah, member for 23 months, OG, last month in orange. Yes, you've got a new courthouse coming next month. It'll be great. The pink will look good on you. How did mullet get the name mullet anyway? Mullet is also a fish, isn't it? I think it's a fish that's commonly used for bait. That trial's already started about the man in Florida, Mark Sievers. Did it start today, Apple Treasure? Or was it previously? Because we also have one that I've recorded. I just have pieces of it all over the place on like 6 different drives I'm trying to assemble. That was in Clark's. Or Brantley, Clark County, I think it was. I can never remember. Judge Brantley's court. Red Pen, let us know what you find on that investigative search. I thought we were watching the one you recorded that we were originally going to watch before we picked up Link. Yes, but I was supposed to get it set up this morning, but instead I was hunting a squirrel in my son's bedroom. That's why I was delayed this morning, so I haven't got that lined up yet. Lawyer Hammer, no longer alive. That's the trial rundown. Did it start today? Did it start? Today was first day? Okay. Hammer trial is old, already convicted. He's appealing his sentence. So this is an appeal? It's a hearing for an appeal? Or I'm confused. Normally that's not broadcast. What as a fish? Ivans, Wisconsin. This isn't a leap any longer. Okay. They're just doing some sort of an appeal. Good morning, Edith. Good to have you here. Welcome. Do you ever find the squirrel? I can hear it, but I have not finished flushing it out of the house and or executing it. One of the two things will happen. Melboy, I'm on the team. Don't care what we watch. I'm just here for chat. Judge McBurney, I saw him this morning. I looked at him a little bit. He is live today. And they've got better audio as well in his courtroom, which is something we needed for a long time. Watched the Hammer trial. I was watching part of it today, but the channel has bad volume. I thought they had fixed that, but we're going to go to Donna Adelson's sentencing later. Need a live trap? Nope. Once it's built a nest in there, it's coming back. It needs to be. This squirrel needs to probably die. You know, sad, but Kiki will eat it. Let's see. That's the case I said was on appeal for conviction and sentence. He's been convicted in 2019. What about peeps calling and sharing how they do decorate their homes for Halloween in general? How get to know you calling ins? The phone, we can have the phone open. I do need to find the charger for it because I'm at 20%. And ever since I uploaded to like iOS 700 or whatever the latest version is, the battery has just been dying so fast. I know that's a strategy from Apple to get us to buy the new one. Somewhere I have a mag mount charger. That would let me charge and talk on the phone at the same time. So maybe I'll just leave it on the charger for a while first. Then we'll talk later. Squirrels go and stew. I have never eaten a squirrel. I don't ever want to. Puppy is right up here on the shelf. He's not in the view yet because I don't have a room big enough to have a camera that can see that. But he's here. Puppy's right there. Just out of view. Maybe I should no, I think the squirrel will just chew the puppy and use the stuffing to build a nest. Seaver sounds interesting. Let's take a peek down there real quick. Well, first, I want to see what I know that Judge Middleton has like 10 sentencings to do today. And I did want to see what was up with that because those get interesting. Let's see what he's doing first.
I bet you can go get a cup of coffee or...
Well, he just stopped talking. And then he just shut down his channel. Judge, thanks for the warning. Thanks for the heads up. Just getting a cup of coffee. Judge Raquel West is live.
A referral service, and they can give you a few attorneys' names as well. Shannon Stott. Good morning, ma'am. You're Shannon Stott?
Yes, ma'am.
Test 1, 2. I'm showing them.
Stott, in cause number 23-41490, you're charged with the state jail felony offense of theft of service, and that's from July 15th of 2022. And since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
No.
So what I'm going to do, Ms. Stott, is reset your case for about 30 days to give you some time to try to hire someone. If you get someone hired before the next court date, just bring the reset notice that you get today to that lawyer. They'll tell you what to do.
Theft of service.
If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers you talked to, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order, and you would have to go back to jail. Do you understand? If you'll step in front of the clerk, she'll give you your reset notice. Yes, ma'am.
Theft of service. Did she like steal her neighbor's Wi-Fi password, or is she like bypassing her power meter? What? Was she putting garbage in other people's garbage bins to avoid paying the garbage fee? I'm curious what that's about. I think it is a Wi-Fi theft.
Thanks for saying your name.
Oh, yeah.
Everybody always says Stout or Scott.
Oh, yeah. Well, that was just a fluke because I'm usually wrong on most of them.
Can I ask you a question?
Yes,
Are you
ma'am.
on YouTube?
Yes, ma'am.
Okay. I follow you. All of this stuff. Am I done?
Yes.
Okay.
Let's see.
Are you on YouTube? Yes, I follow
Yes, ma'am.
you. Thank you. That's not going to help you in your case.
Mr. Turk, you've got pretrial on a Ricardo Rodriguez. Mr. Coleman.
Pretrial.
Morning.
Good morning. How are you?
Ricardo Rodriguez.
Mr. Rodriguez is apparently incarcerated in Edwards County.
Theft of service for walking out on
Yes.
a restaurant without paying your tab.
Morning.
Wow.
I learned of that recently. Oh, that's why he's not returning my phone calls.
There's that.
There's that.
No response, Your Honor.
So he's where?
Edwards County, and I think the city is Rock Springs, but it's 6.5 hours west of here.
Okay.
It's close, like Junction, that area, close to
Okay.
Big Bend area.
Mr. Coleman.
If the state's ready for trial, Judge, we had a conversation late last week that I was hopeful that maybe could resolve.
Yeah, and I always haven't been able to talk to him.
Sure. So, do you have any information now that you know where he is, the status of that, or any?
He's on a revocation. I think he may be set next week. I've called a couple of times to the jail. They don't have a docket only, and so I'm hoping that it's quicker than not. But I can't tell the court over there what to do.
This one's old. Time to get this one taken care of. But obviously, we can't do that if he's not here. If you would maybe contact the DA and maybe his defense attorney this afternoon, if y'all have a minute to do that, and just kind of let me know the status of if they think he's going to get out before next Monday.
Okay.
If he does, then I would like to go ahead and number the case, especially if there's a possibility of getting him back over here and y'all working something out. But just kind of let me know if y'all can this afternoon or tomorrow, any other status that you can find out.
Okay.
Okay.
Just one quick logistics question, Judge, because this is going to require interpreters. And I kind of talked with everybody. Ms. Burge has been working with me to talk with witnesses and Mr. Rodriguez. I was under the impression she's going to sit with me at the table to talk with Mr. Rodriguez and.
We've issued a subpoena for her for the state.
To do what?
To interpret on our behalf.
So that was kind of one of my questions too, is I think there will be several Spanish speaking witnesses, but a lot of the ones that are unemployed by the state. But obviously the officers will speak English, but I need someone.
So I think an issue that we may have for witnesses is that we need, we're gonna need one with the correct certifications. Ms. Burge has one of hers and is able to do that job. I'm not sure about her, I think it's required that we have.
You have 2.
But it's not gonna be just, it sounds like we're gonna need one for several witnesses. So I think we would need
Isla
Master
for
Word
me.
for,
Welcome
I don't
to
know,
the
for one of
gallery.
the other.
Right, that's what I'm talking
And she does great. I'm fine with her doing either, but obviously we need to know that because we've got to get with Master Word to get either one for you or one for y'all. Either way, we'll.
My preference is to have Ms. Burge sit with it because she's up on speed with everything that I've been working on. So that would helpful. That way she could put things in context. And then for the trial, if we need one,
We can get
new
Master
person, so to
Word.
speak.
Okay, let's just see where we are. Y'all
Present a problem, Judge, if she's been privy to conversations between he and his attorney.
I think
the defense.
My concern isn't that she would intentionally, because I don't think she would.
I don't think she would either.
But
No, but I think it would be best if she was there and we got.
It's just avoid any sort of appearances of.
Well, and that would mean you guys would need to get someone else for witnesses. We'll take care of that logistically, but it sounds like we may not need to worry about it this time. So let's just see where we are, make some calls, and y'all let me know. Okay?
Because I think we might be able to move something and get something done.
All right. Thank you. Oh, I'm going to do this also, you guys, since he's in custody over there. I am going to find that he's at large without proper bond on these cases. That way if something happens, he won't just get out. We can get him back here in custody, and that might help us logistically know what's going on. And so in each of his cases, I'm going to raise those bonds. What are they at now? Yeah.
This one's 50, the first one's 50.
All right, I think we have a pro se.
I bet they're both the same. They're both the same.
I think we have a pro se to jump to. Josh just sent us a link for Judge Wolf. It might be our man who we've been. Let's see, it's not this one. That was from 2 days ago. Did we watch this one? No, we didn't because we were in the other court. Let's see what we got here.
So I'm going to give you a set of instructions in a few moments, but those instructions will include, don't discuss this case, don't talk about what it's about, don't try to hypothesize what you think the evidence will be, talk about anything you want to except this case right now. You should not let anyone else talk to you about it as well.
They've got the day
off,
off,
If you were
Ashley.
to leave out to go outside to smoke or something like that, the bailiffs will escort you out through a different doorway so that you don't come back through here because there may be something I'm having to take up that you shouldn't hear. So we're going to ask you to step across the hallway and we'll be in recess for about 15 minutes. When you come back, I'm going to give you this detailed set of instructions. So try to stretch your legs until then. So. All right, thank you.
This one's about an hour long. Give me just a minute to skip ahead through the break. Okay, here we go. Judge is coming back. All right, break's over. Break's over. Judge will be in just a minute. This is our favorite elbowless pro se. This is our guy. This is him. Yep. Velvet Trope has admitted to be, Velvet Rope. I completely butchered your name. Velvet Rope has admitted to being an addict. Welcome. Thanks for clicking the subscribe button. You're one of us now. You can never leave. Do love Judge Wolf. Probably one of my favorite overworked judges. So everybody's just finding their places. See if he's ready to. One of us. Yes. There was some other story I was going to tell you. Oh, went up to Richmond, to Maymont. Do you guys know where Maymont is in Richmond? Judge, don't start for a minute. Hang on. Went up to Richmond in Maymont. I'm going to have to pause the Judge. I've got to pause. Maymont is like 100-acre property that was donated to the city of Richmond as on the condition that the guy who owned it said, when my wife dies, the city of Richmond gets this 100 acres on the condition that they keep this open as a park, open for everybody. And it's beautiful. It's got a mansion. It's a great wedding venue. They've added like a petting zoo and just beautiful gardens. It's got like Roman gardens and Italian gardens, and I guess that might be the same. But Japanese gardens. It's beautiful. It's a very nice park. It has animals like goats and llamas and things like that. And so I thought, well, that would be cool. Let's go. And we went, and I bought the tokens for the feed, right? So you pay basically $1 gives you 2 tokens, and each token is worth a handful of feed. So we bought $10 worth of tokens, or $5 worth of tokens, which is 10 tokens. And then we went to the machine, and there was like 2 handfuls worth of feed in the machine. So we just wasted like $4. But we got all the feed out of it we could. We had to shake it and everything. Everyone thought we were probably stealing stuff. But so we did all that and enjoyed the feeding the goats. I had a what was it? A sheep that ate out of my hand, and I fed a huge bowl. There's like a bowl with massive long horns, and it was sitting there chewing its cud, and I convinced it to get up and walk over to me and eat. And that, I think, is basically like I'm a cow whisperer, because I did that. But I've got a picture of that bowl here that you can't really see because of things. That bowl is probably about 5 feet away from my hand, so it's actually much bigger than that. Its horns are massive, but I made it look like I was petting a little mini bull. And then we went and we saw that they have wild animals as well. Like, this was staring like through a chain link fence. You can't see much, but that's a black bear, and it's a massive one. And to get to this bear, we wandered through a park, like up a little hill. There was like no trail, and around the back, and we're down on the back end. There's like nobody around, nothing. And we're like 10 feet away from a bear, and there's 5 feet of space between 2 chain link fences that are keeping us separate. I'm like, wow, this is wild. Never been that close to a bear that's just eating berries on the hillside. And as we walk down to see if we can see another bear, and I get down to let me see if I can share these. Airdrop. That's the wrong one. We did that one. Okay, there's that one. And then there's this one. Airdrop. Okay. Hold, please. I'm going to share 2 pictures with you. Something I saw, which really surprised me. Media, we're going to bring in, I'm going to replace the FU tree pictures with these ones. There's one, and there's 2. Dang it, they're sideways. All right, they are what they are. They're sideways, but the chain link fence is held together by the gate to get into the bear's den, which has no cameras, nothing around, no people. It's held together by this $5 master lock. And that was the first gate. And then through that gate, there's another gate right next to it, like 5 feet away, and it is closed with another $5 master lock. They do not make many locks easier to break into than these 2. I now realize who wants to lockpick and open and get a bear out, but those locks practically fall open if you look at them sternly. Master Lock, clearly not a sponsor of this. when you're learning how to lockpick, this is where you start because there's the easiest ones to open. All you have to do is put the tensioner in, and usually it opens. You don't have to even do much else other than that. But yes, there's a massive black bear, at least one. There might be two. I only saw one in the cage. There's a massive black bear that is held together, that is kept in its cage with $10 of master locks and no security. So there's that. I just thought I'd, hard pass. It's to stop the bears getting out. They don't have any keys. Was it while feeding the goat you decided to shave off the goatee? No. We didn't feed any goats. The goats were don't feed us. They were in the don't feed us cage, so we only fed the sheep and the cows. And we got bamboo. The four kids all each got a bamboo staff because there's like bamboo forests there. And we may have broken one piece of bamboo down. And I'm like, oh man, they're going to get so mad at us. We're taking the bamboo. And then we found an area where they've actually cut down a whole bunch of bamboo and it's just in a pile to get thrown away. And so we got the rest of them out of there. But we stole some bamboo staffs from them. But that was fun. All right. Let's go back to court now, where judge was talking to us, I think. So let's do that if we can.
Back. I want to deal with this. Mr. Vaughn has filed a motion to dismiss. The motion states as follows: I, Sherrick Vaughn, affirm that the foregoing is true in the best of my knowledge under the penalty of perjury. I move the courts to dismiss for staleness of the prosecution, maliciousness, and lack of notice. Neither witness or trial was given notice more than 18 hours. This is clear prejudice against the defendant and a threat to justice. My prayer to the courts is for dismissal of this court for lack of due diligence, failure to follow notice rule of Tennessee criminal procedure. All right. This is one of the pending cases that has been pending for some time. It is certainly not a new case that's been suddenly brought. It is a case that was one of 4 cases, Mr. Vaughn, that you have had pending in this court. And as a result of that, certainly it is not a surprise or anything that that this case would be suddenly set for trial. When we were in court yesterday, I reminded you that you had filed a motion for speedy trial. And this is a failure to appear, which is not a complex case involving a multitude of discovery issues. It is simply a factual issue as to whether or not you did or did not fail to appear and whether or not there was any justifiable reason for it. And as a result of that, this court granted your motion for a speedy trial and set it for today. And at that point, yesterday, you voiced no opposition to it. And I asked you if you wanted to represent yourself and said, of course. So we are here today only because of the fact that you had requested a speedy trial. We're giving you a speedy trial on this issue. We'll work on the speedy trial for the remaining cases that you have. And but your motion to dismiss is respectfully denied, and we are ready to bring the jury in. Have the juries. Okay. Just hand them to them as they come in.
Mr. Wolf has quite a few items on his docket with this defendant's name on them as he's fighting all these charges. The defendant, for being as educated as he is about the law, which is a significant bit more than the average person, sure has some interesting side hobbies that involve him getting dragged into court. So this is Vaughn's case. We're bringing the jury in. They should come in through those middle doors in the middle. We'll get to watch them. I think it'll be a jury of 6, maybe a 7th one who was an alternate. I was in Gatlinburg, Tennessee this weekend, saw a real wild bear in the open about 20 feet from me. We made eye contact. Oh my goodness. Nope. I'm petrified of bears. Really am.
I think Officer Howell may have mentioned that you can sit anywhere you want to now. There's no assigned seating since we are now past the jury selection. You can spread out a little bit since there's 4 seats on the end if you want to. It's up to you. All right, we're going to read you the initial charge. Ladies and gentlemen of the jury, the defendant, Sherrick Markey Vaughn, is charged in the indictment with the crime of failure to appear. The defendant pleads not guilty to each and every offense embraced in the indictment. Before we begin the trial, I would like to tell you a little bit about what will happen during the course of these proceedings. I want to basically describe how the trial will be conducted and what the attorneys, jurors, and the judge will be doing over the course of the trial. At the end of the trial, I will give you more detailed instructions on how you're to go about reaching your decision, but now I simply want to explain how the trial will proceed. The law applicable to this case is stated in these instructions and those that follow, and it is your duty to carefully consider all of them. The order in which these instructions are given is no indication of their relative worth or importance, rather. You should not single out one or more of them to the exclusion of another or others, but should consider each one in the light of and in harmony with the others. The defendant has been charged by the state of Tennessee with a violation of state law. The document containing the charges is referred to as an indictment. An indictment is the formal accusation charging a defendant with a crime and is not evidence of anything. The defendant is charged in the indictment with failure to appear. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt that the defendant had been directed to appear by a lawful authority, having been released from custody with or without bail on condition of subsequent appearance at an official proceeding at a specified time or place and knowingly failed to appear. The defendant has pled not guilty to the charges. He is presumed innocent and may not be found guilty by you unless, after hearing all of the evidence, attorneys' arguments, and instructions of law, the 12 jurors seated in this case unanimously find that the state has proven its case beyond a reasonable doubt. The first step in the trial will be the attorney's opening statements. The state will tell you about the evidence it intends to present so that you will have an idea of what the state's case is about. This opening statement is not evidence. Its only purpose is to help you understand what the evidence will be and what the state will attempt to prove. After the state's opening statement, and it says an attorney for the defendant, but the defendant representing himself may make an opening statement if he should so choose. Again, statements of attorneys are not evidence. Next will be the state's case in chief, in which the state will present its evidence. The evidence in the case will most likely consist of physical exhibits, documents, and the testimony of witnesses. The witnesses will testify by answering questions asked by the attorneys. Venue of the offense lies in the county where the offense was commenced or consummated. If you find that the state has failed to prove by a preponderance of the evidence that this offense was commenced or consummated in Dixon County, Tennessee, then you must return a verdict of not guilty. After the state completes its case in chief, the defense will be given an opportunity to present evidence through witnesses and exhibits. A defendant is not required to put on any evidence or to testify. The burden is always on the state to convince you that the defendant is guilty beyond a reasonable doubt. If the defense does present proof, the state may then put on what is known as rebuttal proof. After the state's rebuttal, the defense may put on further proof. After you've heard all of the evidence, the state and the defense may present final arguments. I previously told you that opening statements by the attorneys are not evidence. Likewise, closing arguments are not evidence. In closing arguments, the parties will attempt to summarize their cases and help you to understand the evidence there was.
A few more. I think half the trial is him reading. Need to look up, Judge. Okay, here we go.
September term, grand jury, 20.
Before taking a break. The usual break times are at 10:30 in the morning and 2:30 in the afternoon, with a normal hour between 12 and 1 for lunch. If you need a break at any other time, please ask. A juror who is distracted is not paying full attention to the testimony. Both parties are entitled to your full undivided attention to this case. If after your deliberations you find the defendant guilty of any offense, the court will set the punishment at a separate sentencing hearing. The jury will not be involved in setting the punishment. This completes my opening comments to you. The next phase of the trial is the formal reading to you of the indictment in this case. General Bryson.
General Bryson steps up to the podium to read the indictment. grand jury indicted him for failure to appear?
In the circuit court for Dixon County, Tennessee, at Charlotte, September term, grand jury, 2024. The grand jurors of Dixon County, Tennessee, duly impaneled, sworn, and upon their oaths do present that on or about July 24th, 2024, in Dixon County, Tennessee, and prior to the finding of this indictment, Sharik Marquis Vaughn, then and there, did unlawfully and knowingly fail to appear in the circuit court for Dixon County, Charlotte, Tennessee, as directed by the circuit court for the purpose of attending an official proceeding, to wit, trial date for docket cases 22 CC 2022 CR 336, 2022 CC 22 CC 2023 CR 227, and 2022 CC 2021 CR 462 in violation of Tennessee Code Annotated 3916-609 and against the peace and dignity of the state of Tennessee. Signed, W. Ray Crouch, Jr., District Attorney General.
Mr. Vaughn, to that indictment, how do you plead?
Not guilty, Your Honor.
Plea of not guilty is entered. The next step will be for the opening statements of the lawyers or of Mr. Vaughn, if you choose to do so. General?
Judge, I'll waive an opening.
Mr. Vaughn, do you wish to make any sort of opening statement?
No, sir.
All right. Opening statements have been waived.
fast.
Therefore, the state may proceed with its proof. You may call your first witness.
State will call Pam Lewis.
Ms. Lewis, if you'll come forward, please.
The bailiff moving crew comes and rearranges the furniture. Well choreographed. Here's our witness.
Are you Pam Lewis?
Yes, ma'am.
And you are our Dixon County Circuit Court Clerk.
Yes, ma'am.
How long have you served as the Circuit Court Clerk?
Since 2002.
And what is the general duties of a Circuit Court Clerk?
General duties of the Circuit Court Clerk is to maintain the court records.
And either you or your staff are present for all circuit court dates?
Yes.
And in this case, we are here, Sharik Marquis Vaughn is on trial, and we're going to be talking about him. Is he here in the courtroom?
Yes, ma'am.
Could you point to him?
He's sitting at the defense table.
Judge, if the record would reflect that she's identified the defendant.
Record will so reflect.
And did the defendant have a trial date set on July the 24th of 2024?
Yes, ma'am.
Okay. And he had 3 cases set for trial that day?
Yes, ma'am.
And when someone has a trial date coming up, how do they know that they have a trial date coming up?
When they come to arraignment, we check to see if they need an attorney, and then they are given a plea date and a trial date.
And what was the date of the immediately preceding court date for the defendant? So when was the last time he was in court before that July 24th trial date?
July 19th.
And that was here in Dixon County?
Yes, it was before Judge Lockard Mash.
And he needed to appear in the same courtroom that on July 19th as he was on July 24th?
Yes, ma'am.
And was his court date announced on that July 19th date?
Yes.
Now, would he have known about the trial date before that July 19th date?
Yes, he was notified in March of 2024 when Attorney Flanagan filed a motion to withdraw his counsel.
So he was aware of the court date in March and then was in court, let's see, the 19th to the 24th, 5 days before his trial date?
Yes.
Now, on the date of a trial, such as the one scheduled on July 24th of 2024, does your office bring in a jury panel?
Yes, ma'am.
And was a jury panel brought in for this trial?
Yes.
And did the defendant show up for his court date on July the 24th of 2024?
No, ma'am.
And you have reviewed all 3 docket sheets for all 3 cases listed on the indictment?
Yes, ma'am.
And he was not present?
He was not present.
Bust.
Judge, that's the state's questions for this witness.
Mr. Vaughn, do you have questions you want to ask of this witness?
I do.
All right.
Good morning.
Morning.
Okay, I believe you just stated to Miss Bryson that your job title is to maintain court records.
Yes, sir.
Okay, what type of records are they? Like,
We have criminal records, civil records.
okay. Okay, are you biased against me?
No.
You are not?
No.
Okay.
I'm sorry. That's his number 2 question.
Do you recall speaking to, are you familiar with who Scott Tummins is?
Yes, he's a bondsman.
Yes, he's a bondsman. Did you happen to speak to him at the time when I was alleged not to appear?
No, sir.
Okay, I don't have it with me. I have, on some of your records, it says that you spoke to Scott Tummins and as well to Lee Spratt. Do you not recall your record saying that?
No, sir.
Okay, it says that, that the copy I have, that you spoke to Lee Spratt and Lee Spratt spoke to you and said he had no contact with me.
That was the day of the trial. He announced he had no contact with you.
Okay, is Lee Spratt my elbow counsel?
He was, yes, sir.
He was my elbow counsel?
Yes, sir.
So he can make statements on my behalf and testify on my behalf?
Yes.
He can, without my lead?
No, not without your permission.
Okay, so he did that free will?
I guess so.
He's throwing his elbow counsel under the bus?
You said that you keep a record of everything filed into this court. Have I ever filed a complaint against you?
No, sir.
Have I filed any paperwork to have you recused or anything in this court?
Yes, I do believe you did.
Okay, I did. Okay. Was I ever charged with another failure to appear out of this court?
I don't believe so. Not that I remember you haven't been.
One that I back last year and I was released upon out of this court.
Recruised.
Let me think.
That's when Disney lets you go on another one.
No, July 19th, the day you was here, that Judge Lockard Mash reinstated to your bond. That was the day they dismissed the first one because you gave reason why you did not show up the first time.
Correct.
That was prior to the July 24th.
That's the right answer.
What was the reasoning for that one?
I do not remember what reason you gave.
Could it possibly been some messed up paperwork?
It could have been.
Okay, what about this time? Do you think that could have possibly been?
No, sir. No, sir.
Worked last time.
That's all.
Redirect.
He thinks this is a joke. The jury's been dragged out of their jobs, dragged to the courthouse.
No, Judge.
Thank you, Ms. Lewis. You may step down. May she resume her duties.
And I'm surprised she wasn't arrested earlier. I thought this
You want her at the
state
table with you.
would prosecute.
Go back to the table and have a seat. State may call your next witness.
Judge, that will be the state's case in chief.
State has rested their proof, Mr. Vaughn. Ladies and gentlemen, if you'll step across the hallway for a moment, let me take up one matter.
He did that whole thing, are you biased against me? To ask, is it possible that this was just a paperwork mix-up? And she's like, nope. Nope. And he laughs. The jury's like, you're seriously? I got dragged away from my grandkids to be here so you can laugh about maybe this was just a paperwork mix-up? Yeah.
All right, Mr. Vaughn, if you'll come to the podium, please. Mr. Vaughn, the state has rested their proof, so the next question is whether or not you want to present any proof. I want to go through your rights as a defendant to make sure you understand what your options are. We did this at the last trial, so I'm sure you're familiar with it. But I'm going to ask you to raise your right hand and let me place you under oath for the sole purpose of this examination. All right.
You can barely hear the court official that swears him in, but it is happening.
Fine.
Mr. Vaughn, you are representing yourself, but even as a defendant representing yourself, you have the right to testify at a trial, at this trial. And if you choose to testify, then no one can stop you from testifying if you want to give your version of the events and so forth. Likewise, you are not required to testify, and no inference of guilt will arise if you choose not to testify. No one can make you testify if you don't want to testify. So the question becomes, do you wish to testify at your trial, or do you want to waive your right to testify?
I'll waive it.
You're going to waive your right to testify?
Yes, sir.
All right, then have a seat. Bring the jury back.
Jury entering.
I'm sorry. Okay.
Jury takes longer to get back to the court than the whole prosecution's main case took. We're going to fast forward through the jury instructions since that's also way too long for this case.
All right, ladies and gentlemen, the state has now arrested Mr. Vaughn. You, as the defense, have the right to present proof. Do you wish to put on any proof?
No, sir.
All right, then the state has rested, the defense has rested, so you will now hear if there's any closing arguments that the sides wish to make, then you will hear from them.
Ladies and gentlemen, this is probably the shortest jury trial that has happened in this courtroom. It's okay, you don't have to.
Buff bailiffs move the
The defendant is charged with failing to appear on his trial date, July 24th of 2024. You have heard testimony that he was in this courtroom on July 19th, just a few days before that, where he would have known of his court date, and that just a few days later, he failed to appear for that court date. And as such, the state will ask you, you're going to receive instructions from the judge and a jury verdict. You'll go back and elect a foreman, and the state will ask you to return a guilty verdict for failure to appear. Thank you.
Mr. Vaughn, you have the right to address the jury, but you may not testify. You may only argue about the facts.
Good luck.
You just heard me ask the witness multiple questions about whether she was biased and whether I filed a complaint against her. She testified that I have. You've also heard that I've been charged with failure to appear at this court before too, and it was also dismissed. You've also heard that I've asked the witness whether there has been errors made before in my case, and you also heard her state yes. I'm asking y'all to take this and do the best y'all can. Thank y'all.
State has the final say if you wish.
Judge, I'll waive.
All right, and ladies and gentlemen, we have a final set of instructions to get to.
And we're gonna zip through the final set of instructions because they take way too long, and we're gonna go to right here. Hang on.
For which days, Your Honor?
Oh, well, back up.
of the proceedings. Was that?
Doubt, you shall return a verdict of guilty for that offense as to the defendant. On the other hand, if you do not find the state if you find the state has not proven beyond a reasonable doubt the defendant's guilt, or if you have a reasonable doubt as to his guilt, then you must find him not guilty. In that event, your foreperson will report that you found the defendant not guilty. If after your deliberations you find the defendant guilty, the court will set the punishment at a separate sentencing hearing. The jury will not be involved in setting the punishment. You may now retire to begin your deliberations. Ladies and gentlemen, I have prepared a verdict form that will go back with the original of the charge, and it simply finds a place. It just provides that in the indictment for the charge of failure to appear, we, the jury, find the defendant, Sherrick Markey Vaughn, either not guilty or guilty, and you check one and the foreman signs it. So, ladies and gentlemen, if you will step across the hallway, you may begin your deliberation.
Okay. Let's see, I'm not sure where my timer went, but wait for the door to close.
This will go back with that. Right, while we are here, General, we have discussed trying to conduct another one of Mr. Vaughn's trials on the 23rd and 24th of this month.
Yes, Judge. One of my victim witness coordinators is calling this morning to all of the witnesses in the simple assault case to confirm their availability for that trial. I've not had a chance to see if she's got in touch with everyone.
As soon as you know anything, if you can find out before we are adjourned today, I would appreciate those. Mr. Vaughn needs to know if he's going to trial on the 23rd and 24th.
Is my witness still to need to be subpoenaed for
Which
that?
witness is that?
Jennifer Dozier. I placed in a motion for her to be at every one of them, every pending case.
I don't know. We need to make sure that Ms. Dozier was subpoenaed for this trial, the next trial. Problem is we don't have a trial date, so it's hard to subpoena somebody to let them know they have to be somewhere when we don't know what the trial date is. But there should be a subpoena issued for her. Is she still in Savannah?
Yes.
All right. All right, Mr. Vaughn, if you'll step back with the officers, we'll bring you out when the jury is returned.
I have a quick question, if I could, Your Honor.
Oh, sure.
This is about yesterday, if I can just gain some clarity.
All right.
I haven't had the chance to go through that paperwork yet. Was a transcript in that paperwork?
A transcript of what?
Of the proceedings. Was that in that
Are
paperwork?
you talking about a typewritten transcript?
Yes, sir.
No, that was not provided. What was provided was the entirety of your file here in the court. As far as if you're asking for a transcript of every time you appeared in court, that will be a lengthy procedure to have to identify what days we're talking about. Then the court reporter would have to have a sufficient length of time to type everything up, which will be a very difficult thing for her to do on a short-term situation. So. Okay. All right, so there's an order granting you a transcript, but you don't have it yet.
For which days, Your Honor?
Well,
all right, thank you, Your Honor.
Oops, sorry. Put them in the wrong order. So he does get his transcript. Man. It's just costing this court a fortune.
thank you. Thank you. Okay. I appreciate it. All right. Well, we'll take a recess until the jury returns.
Judge, don't go far. just looking here, it looks like the jury's going to be back very soon. Like so soon that I think I might want to take the clock down, and then we can just fast forward. What do you think? Doesn't make anything simple. No, he's a pain in the butt. Kurt, sounds like you've got a fun morning on tap. No poll. It's just going to be by a show of hands. Listen very carefully. If you are on the defendant's side and believe that the evidence shows that he, in fact, did appear for his court date, as was scheduled, just raise your hand in chat. If you think the defendant is right and that he should not be found guilty. JT? Is that just on principle? That's not the burden of proof? Beyond reasonable doubt. That's a burden of proof, right? A couple of you are sitting on your hands. He pledged to show up. Okay, we'll fast forward just for a little bit because we can. Waiting for the judge who was watered around somewhere. If you're wearing earplugs or headphones, just know that you might not it might be a little jarring here in just a moment. Bailiff's ready. Prosecution sitting there ready. I think we're just waiting for the defendant.
All right. Jury has reached a verdict, so we're going to bring in Mr. Vaughn and we'll find out what the verdict is.
In less time than it takes the jury to use the restroom, they have decided the verdict on this case. Mr. Vaughn charged with failure to appear for a previous hearing on July 24th earlier this year. Mr. Vaughn facing a litany of charges, which he's broken down to individual cases, which he himself is defending. To his detriment, I have to say. A smart man, but not doing the smart thing. So jury comes in here now with a verdict which can only go one way. Not because the form only had one answer on it, but because all the evidence seems to point to the fact that he, in fact, did not appear. The court clerk herself swearing from the witness stand that he did not show up on the date in question. Mr. Vaughn's defense was, could there have been a mistake? She said no. So let's wait for the jury here. Mr. Vaughn choosing not to stand for the jury, not even making eye contact, as he's been convicted by a jury in this court previously. Different jury, because that would be a bias if they had convicted him previously. So each time they have to seat a new jury. So here we go. You may be seated, please. All right.
All right, ladies and gentlemen, I'm told that you have reached a verdict. Is that correct? Will the foreman please stand and announce, as to the indictment, the charge of failure to appear, how does the jury find the defendant? Guilty or not guilty? All right, is this the unanimous verdict of all? If you will, signify by raising your right hand. Show that all jurors have signified that this is a unanimous verdict. Thank you, ladies and gentlemen. We're going to dismiss you now, but thank you for your time and attention. As I explained to you, every person has a constitutional right to try a case that they're charged with before a jury if it involves any type of incarceration. So the fact that Mr. Vaughn tried this case today just means he was exercising a constitutional right that we give every defendant. Thank you for your time and attention, and we're going to allow you to be discharged. I wish I could tell you don't have to answer the call the next time, but we need you to check that number after 6 p.m. on the 22nd for possible service on the 23rd. And you may free to go. If you'll exit through this door, there's another exit they can let you. If there's anything you have that you need to get out of the jury room, please do so. Thank you.
Get your dozen eggs and go home. They said guilty. We couldn't hear it, but it was an easy one. This is one court where we cannot hear the jury.
We have set a sentencing hearing on Mr. Vaughn's other charges on January the 28th, so this case will also be combined for sentencing on that charge as well.
That's our sign. It was guilty.
And we are trying to determine whether or not it's possible to try one of his other cases on the 23rd, and I assume you're going to have to check and...
He's requested speedy trial, which is...
Right.
Sort of
let us
tied
know
the
as
court's
quickly
hands.
as possible. Mr. Vaughn will get word to you at the jail as quickly as possible once we know that the trial on the 23rd is going to go forward. So that will be for the simple assault.
Yes, Judge.
Would that be like, you're going to send me a letter or something?
Actually, I think, yes, they'll have to send you a notice at the jail from, where are you housed, in Decatur?
No, I'm here.
He's here.
I've been here.
Judge, I will, I normally, when I'm
personally
dealing
visit
with an
him.
attorney, I normally copy that attorney on my email to the clerk for my witness list. And so I will write Mr. Vaughn a letter confirming and giving him a formal witness list.
Okay.
All right.
All right, so we have, right now, as far as the cases that remain of Mr. Vaughn's, we have two more indictments, is
Well,
that correct?
we'll still have to go back and try the driving on revoked.
Well, we could do that on the 23rd, if nothing else, couldn't we?
Yes, Judge, I should be able to do that. I'll check with Officer Javen.
That's the driving on revoked third offense that he withdrew as guilty. I would allowed him to withdraw his guilty plea.
Yes, Judge. And, I mean, I could probably try those. I mean, if I try one on the 23rd, I can try the other one on the 24th.
I think that would be a good plan. So, all right. Then we'll let you know as soon as possible, Mr. Vaughn, whether we're going to be trying some more. We can expect to try at least one of those cases, the driving on revoked license, on the 23rd or 24th, depending on one of those 2 days. Just expect you're going to go forward on your driving on revoked license that I allowed you to withdraw your plea on, and that will take place. We'll need to make sure that it's a separate jury panel. So.
That's the pain in the butt for the court.
All right.
Separate jury each
Mr.
time.
Vaughn will be remanded to the jail until his next trial date. We stand adjourned.
So there's going to be another trial that will most likely result in a conviction. I say that because the evidence that we've heard thus far has been rock solid against him driving unrevoked. And I think in his own remarks to the court, he has acknowledged that he in fact did do that. So I'm guessing the jury's going to convict unless there's some sort of, jury nullification going on, which I just don't see happening. The judge, I don't think, would allow it. And so there'll be like 4 different sentencings happening at the same time on the 28th. He's going to get just a big universal judgment, most likely against him.
It would be
checking in with
videos
Texas now.
in regards to the accident that is related to this incident.
Okay. An accident?
I see roses.
I know. There's an accident involved with it.
Okay.
I need to get with the victim on her to see if she still has them, and if she does, I will upload them and
goes into defense.
Okay. And how long is that going to take?
Maybe at least 30 days would be great.
All right, Ms. Ferguson. Set this in 30 days for discovery and plea deadline date.
Yeah.
All right, November 13th, once you sign the reset form, you're excused.
Thank you, Judge.
All right, thank you. Thank you.
We're in Judge Boyd's courtroom in San Antonio, Texas. This is live. They are working on his Columbus Day. Looks like they have a full docket as well. I see we have a news camera in the back filming possibly a high-profile case coming up at some point today that they're here to follow. Not always have a news camera here.
All right, Alfredo Rodriguez. Who's the attorney for Alfredo Rodriguez?
Judge had a haircut.
All right, we're going to go on the record. Court is calling 2023 CR 0474 State versus Alfredo Rodriguez Jr. Can I have parties announced for the record?
Megan Galloway for the state.
Rafael Leal for Mr. Rodriguez Jr.
And are you Alfredo Rodriguez Jr.?
Yes, ma'am.
All right, did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Alfredo Rodriguez Jr. who was placed on deferred adjudication in 2023 CR 0474 for the offense of possession of a controlled substance penalty group 1 to 4 grams on March 3rd, 2025 for a period of 4 years? Is that you?
Yes, Your Honor.
All right, state.
Violation of condition number 4 in Bexar County, Texas. The defendant, Alfredo Rodriguez Jr., did then and there fail to report to the supervision officer as directed for the month of May 2025. Violation of condition number 4.
How would you plead to that? True or not true?
True.
We waive and abandon the remainders, Your Honor.
Any objections to the waiver?
No, Your Honor.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, ma'am.
Court will find violation of condition number 4 true. Is there a proposed agreement?
There is, Your Honor. It is for the court to grant the state's motion, enter an adjudication of guilt against the defendant, revoke his community supervision, and sentence him to 2 years in the prison.
All right. So what has he done on probation?
Judge, he had a problem with drugs. He took some drugs, and I don't think he had the appropriate or the enough follow-up on the recommended treatment. And plus, added to the fact that he did not have transportation or means to get transportation, and I don't believe he even had a telephone to communicate or establish communication with the probation officer.
All right. Is there anything you want to say?
No, Your Honor.
All right. So probation, has he done anything?
It's half evaluation.
So that means you have not done anything. Like, where has he been? Because I set conditions for him to help him succeed. If he had a drug problem, there are conditions in here for his drug issues to address those issues. He obviously had children or still has children. And I say had children because I don't know if they're adults at this time, but I asked him to complete parenting classes. Did he do that? So it appears the only thing he did was answer some questions and then he disappeared.
Unfortunately.
All right. All right, State, you may be excused. Is there anything you wish to say? All right, the court is going to find you guilty. The court will revoke. The court is going to sentence you to 4 years in the prison, give you credit for any time served. The court will recommend the therapeutic community, and there's to be no unsupervised contact, with minors. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? You have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you're on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing. You're going to have to make some changes in your life, right? In this court, communication is always key. If you have a drug problem, you just come in and let us know and we'll do what we can to help you. But if you don't reach out, there's nothing we can do.
Fine.
And the reason why you're receiving the 4 years, I consider everything. You haven't done anything on probation. You understand?
Yes, ma'am.
All right, when you're released from custody, if you cannot find a sober living house or you can't find somebody to address any drug issues you may have, if I'm still here, you come back here, I'll get some help for you, okay?
Yes, ma'am.
All right, good luck to you.
Thank you.
You're welcome.
Wow. Thank you. You're welcome. 4 years. Okay, here comes cameraman has set up. This looks to be filming. I'm not sure if that was the person they came for. Looks like he's following this case. Not sure if he's just framing the shot. But he got it. He's now moving his camera. Some courts don't even allow you to move your camera while the court is in session. So this court's quite lax.
All right, anyone else?
John, okay.
All right, what page? I'm so sorry.
Page 2.
Oh, Lopez. I thought you said Lucas. Okay. All right. John Castro Lopez.
Amber coming in with the jokes.
All right, today is final plea deadline date. So have you all reached an agreement?
No, you are.
All right, how long do you expect this trial to last?
Judge, if I had to guess, probably about 3 days or so after jury selection.
All right, Ms. Ferguson, if you can set this for a jury trial before the new year, please.
The eyebrows go up
And
on the
if y'all have not tendered an acknowledgement, a new acknowledgement discovery, I see one was tendered on July 28th. So if there's anything new, if you'll make sure you do the update.
Okay. Today, Judge?
Yes, please.
Yes, ma'am.
If you're able to, I know you're.
It's a little weird right now, but I can do it, yeah.
All right. And it's 3 days.
I'm actually going to be out of, and then we have the 11th off. I'm actually out of town on the 10th. So
there's that.
I'll be back. Yes, that should work for me.
All right.
November the 17th.
Your jury trial is November 17th. Your plea deadline date has expired. The court will not consider any plea bargain agreements in this case without good cause. Otherwise, you'll have to plead open to the court. Do you understand? All right.
If I may, November 17th, I have a special setting already for several months in aggravated sexual assault of a child in Page County.
Okay.
Especially since it's been going on for a couple of years.
All right. Ms. Ferguson,
new date.
Recall this back for October 27th. And we'll do jury selection on the 27th. Yes.
Judge, I'm going to be in trial on October 27th.
Where?
Comal County.
All right, let's see if that happens. All right, so you all will be back here on October 27th for jury trial. All right, thank you.
Wow.
Judge, I anticipate I'm supposed to be in trial on the 290th, but at the same time, we'll see what happens. So.
All right, okay, thank you.
Yeah.
She's like, Bring it. I'll schedule over the top of their trial. Wow. 21 months of you getting to enjoy my sparkling wit and charm. Taking a leaf out of Greeter's humble views. Best place to be and keeps me sane. Thank you, Ari Mazzachet.
Pardon me.
What are you?
Mario Hernandez.
Oh, you'll need to sign in.
Mario Hernandez. Sloth Life, thank you so much. OG. Hope your day is going well. She's like, yeah, we'll see. We'll see who blinks. We're going to play chicken with another court.
And Norma, if you would call Robert Maurer, please. So that we can take care of his client who's unsigned.
Yeah. It's funny how judges sort of battle each other.
Scott Hill, who do you have?
Good morning, Judge. I have Ryan Rios. I'm not sure if he's online or not.
Hello, Scott, who do you have?
Judge, I've got Ryan Rios. I'm not
so
sure if
sorry, I
he's
cannot
on
hear
Zoom.
you.
The monitor, Judge. The monitor just
Turn your volume's down, Judge.
We always have problems. It was fine before.
Who touched it? Who's been messing with the monitor in Judge Boyd's court? I want to see who this cameraman, the news cameraman's here for. Judge Boyd does occasionally have some pretty high-profile cases go through her courtroom.
Scott, I just sent you a chat.
Responds via text.
Anyone else ready?
No, I do. I didn't say that. They'll be here. Page 3 at bottom, Judge.
I think we've seen that purse before.
Melissa Paez.
Yes, Your Honor.
There's a state rep wandering around Boyd's court.
Hi, we have Anaya.
Yes, I'm going to confirm. I'm going to go out and call her once I talk to Mr.
All right, thank you. All right, State, were you able to tender an offer?
Yes, Your Honor.
All right.
Judge, we're
I
on
can see her
case number
now.
2025 CR 008396.
I think she can see me too.
Ms. Pius has been indicted as a habitual,
Mhm.
and I'm not on the first degree level.
Okay.
So I respectfully ask the court to appoint someone to, if you want to, I can file my motion to withdraw.
Yeah, we'll appoint someone.
Okay.
Just have a seat. So we're going to get a new attorney for you. All right. Thank you.
Thank you, Judge. May I be excused?
Yes.
Thank you, Judge.
Thank you.
Mr. Simpson's doing court. He's in Bayer. Yep, maybe today. It might just be a hearing. It's probably just a hearing. I don't think she has a court case, but I'm sort of wondering. Hello, Mr. Scott. How are you doing? Feel awfully close to you. Which one's Mr. Simpson Schmoopy?
Yeah.
Somebody's on the red phone there in court. Who's that?
No, that's fine.
Do you want to go to that one?
Okay, if it doesn't work.
Yeah.
Let's jump down to Warren County.
Be able to follow my instructions and admonitions
Rashawn?
over our break. We're now going to hear the
I don't
opening
see it on
statements
the
of the
docket.
attorneys. As I told you before, the opening statements are not evidence. They are the opportunity that each side has to preview their case for you.
This is a new case,
We've
Warren
agreed in
County.
advance that each side will have up to 15 minutes for
Live
their opening.
opening statements
Mr. Chairman,
right
you
now.
may proceed.
Thank you, Your Honor.
Warren County.
Ladies and gentlemen, on July 23rd of 2024, defendant was incarcerated at the Warren Correctional Institution. Officers had received a tip that there was a possible weapon located in the defendant's cell. Pursuant to policy and procedures in place at the prison, Officer Sycama and Officer Romine, on duty at the time, and partners, plan to conduct a cell search of defendant's cell in an effort to locate the alleged weapon. They called for assistance from another officer who was in the block next door. Officer Blythe responded. They removed the defendant and his cellmate at the time from the cell and placed them in the day room outside of the cell. Everyone else on the block had been locked down, so the only person out was the defendant and his cellmate. They conducted a search, and during that search they encountered numerous items of contraband. Items that the defendant and his cellmate were not allowed to have pursuant to prison policies. Items they were prohibited from possessing, such as a large amount of homemade liquor, homemade wine, items such as pillows and blankets that had been made from materials that they were not supposed to be possessing.
They had jailhouse hooch.
And also fans that were in altered condition. Inmates are typically, you're going to hear, inmates are allowed to have fans. However, if they are altered in any manner, they are not allowed to have them, and they're considered to be contraband. As these items were being removed, you're going to see the video of both the cell search and of the surveillance on the day room where the defendant was located. He became increasingly upset, yelling and cussing at the COs, and eventually knocking a water cooler off of the table.
Oh, we have video. Let's see. That's a nice igloo, too. He's eyeing up the water cooler. Boom! He walked two water coolers. I hear taser, taser, taser. No taser. Bum. Love being able to see the video.
Now, once that happens, what you just saw, knocking the coolers off the table, the officers on scene gave multiple directives to the defendant to cuff up. They're going to tell you about pre-aggression indicators and the pre-aggression indicators that the defendant was exhibiting during this encounter. He was becoming increasingly upset, increasingly more violent, increasingly more hostile, and for officer safety, they instructed the defendant to cuff up. And as we discussed in voir dire, that means turn around, put your hands behind your back, and I'm going to place handcuffs on you. Multiple times.
That's
5,
different from
6,
throw down.
7 times, upwards of 8, 10 times. They instructed him to cuff up. He refused to do so. Increasing in volume, increasing in aggression, demanding, they call a white shirt. You're going to learn that a white shirt is a supervisor. Okay? He refused to comply. and they ended up deploying what we call OC spray, which is pepper spray, in order to try to
do show us that.
contain the defendant. And eventually, all three of them pulled out the spray. They sprayed him. Now you're going to hear as a result of this spray, it's kind of goes all over the place too. So not only are they hitting the defendant, they're getting the backsplash from the spray as well. So affecting their sight, their vision, their ability to contain the defendant as well.
Spoils lunch. Everything is bad.
You're going to hear that there is a process for an inmate who wants to contest items that are removed from his cell. Inmates are provided that process as soon as they enter the prison system. There is a procedure that they follow. Things are reviewed, and an independent board makes the determination whether or not the item should have been removed from the cell. The procedure is there for a reason. The process is there for a reason. It's there to keep the situation under control at the time. It's there to keep everyone, inmates included, safe. Now, after being sprayed, you're going to see additional video, and the defendant kind of moves over to the left side and ends up near a wall and a door. Officer Blythe, Officer Sycamore, and Officer Romine follow him, and you're going to see handcuffs out, still giving orders to cuff up. The defendant is still resisting. A hand is placed on his back. He is not pushed. He is not shoved. A hand simply is placed on his back in an effort to get the handcuffs on. At that point, you're going to see video, and the defendant flips out. He spins around. He starts hitting and punching the officers involved. 3-on-1 at this time. Defendant, as you can see, is a bigger guy, and 3 officers still are not able to contain him. Officer Sycamore, as a result of several punches to the face, ends up suffering from a fractured tooth. He ended up having half of it broken off. You're going to see photos of that. And Officer Romine, in addition to being hit multiple times, ends up at the defendant's mercy in a chokehold. He has an arm around his neck for upwards of 30 seconds, which may not seem like a long time, but 30 seconds is a heck of a long time when you can't breathe. You're going to see that video
more serious,
and from multiple angles, and you're going to hear Officer Romine calling for help. You're going to hear his voice, and it's going to be evident in the sound on that audio that the man could not breathe. He was in fear for his life. It took ultimately 6 or 7 officers to finally contain the defendant and pull him off Officer Romine. Corrections officers, ladies and gentlemen, have an extraordinarily dangerous job. Rules are in place in the prison for a reason. If those rules aren't followed, people get hurt. The defendant did not follow the rules on July the 23rd of 2024. He threw a temper tantrum because they were taking away his fan. And unlike that toddler we discussed
it was his
in
only
one
fan.
year that can be simply redirected, this is taking place in a hostile, dangerous environment. And instead of simply following directives to cuff up, which would have ended the situation immediately, he chose to fight, he chose to hit, he chose to punch, And he chose to strangle individuals who were simply trying to do their jobs. This is not a self-defense case, ladies and gentlemen. This is a case of officers following the rules, following procedures, and defendant knowingly causing physical harm, serious physical harm, to Officer Sycamore and Officer Romine. And we were going to ask for a finding of guilty as to all charges at the close of evidence. Thank you.
Mr. Engel?
Thank you, ladies and gentlemen. The nice thing about a trial is that you get to hear both sides of the story. And this case has a lot more to it than the outline of the facts that the prosecution laid out.
The video of the offense.
What are the evidence you're going to see in this case? Well, the evidence you're going to see, and I'll make sure, can everyone hear me okay if I'm away from the microphone? Okay. Because I don't want to block the viewer. The evidence in the case you're going to see are the ODRC videos and their policies. ODRC, Ohio Department of Rehabilitation and Corrections. You're going to see not just this little video that the prosecution showed you in opening from the surveillance camera. You're going to get the body cam video of the officers. And you're going to get to hear what happened before this incident, how this incident happened, and what it was. Because I agree with Ms. Tranter. The evidence in this case will be about following rules and following procedures. But the evidence in this case will also include the policies and procedures that the corrections officers are supposed to follow. And what you are going to hear in this case is three things. First, the corrections officers in this case created the situation and provoked Mr. Thomas. Number two, you are going to hear that the corrections officers violated their duty under their policies to de-escalate the situation. And third, you're going to hear that they used excessive force in order to gain compliance. So what do we mean by that?
Mr. Engel, if you could move towards the microphone so that the recording can pick you up.
Okay. And I think if I stand here, I won't be in the way. First thing you're going to hear about a personal property policy. And you're going to see in this policy that, quote, it is the policy of the ODRC to provide IPs, that's incarcerated persons, the opportunity to possess a reasonable amount of personal property. In other words, you're going to see that cell and it's got stuff in it. He's allowed to have that stuff in it.
Got a lot of stuff.
You're also going to hear about a search policy. And two things are going to be important in that search policy. First, reasonable care shall be taken during the search so as not to damage or destroy cell contents or fixtures. In other words, they have to be respectful of the inmate's personal property. The second thing you're going to hear is that if there is contraband,
yes,
that the location at which it is discovered must be documented. And I'll tell you what, you're never going to see, in this case, a list documenting contraband in this case. Most importantly, you're going to get a copy of the use of force policy from ODRC. And I want you to focus on, when you hear the testimony, the section dealing with duty to de-escalate. And it says that all staff are required to use interpersonal communication skills and behavioral intervention techniques to de-escalate a situation whenever it is safe and possible to do so. In other words, you're going to hear that they can't just go to their pepper spray, which is force, and spray people in the face when they have other techniques available to them. You're going to hear and read that they should be mindful to create physical space between themselves and a hostile incarcerated person who does not pose a danger to self or others, allowing for time and distance to be factors in managing an incarcerated person's behavior. And I want you to note in that video, if you saw, the only inmates there were Mr. Thomas and his cellmates sitting there. Everyone else, the place was empty. The place had been emptied out and everyone was in their cell other than these folks while their cell was being searched. So you saw a lot of space. I want you to note that space and that distance that's there. You're going to hear about him asking for a supervisor. And that's consistent with the policy. The policy requires these corrections officers that when initial interpersonal communication efforts do not improve the situation and there is time and availability, staff should consider bringing in crisis responders or other appropriate staff members to assist in resolving the situation. And finally, and this is going to be a key factor, the policy says you can't create the situation and then use force to resolve it. In other words, the obligation is on the guards to be respectful at the very beginning and not provoke it, because it says that they're expected to maintain and display respect and professionalism to one another and the incarcerated persons for whom they are employed to manage safely and humanely, and you should pay attention to this, to minimize the need for the use of force, an employee should never verbally or physically provoke or abuse an incarcerated person. And then you'll hear about the investigation, which includes the same thing, that they're supposed to look for any other policy violations or procedure violations related to the use of force. So what happened here? Well, what happened here is correct, that there was supposedly a tip, or they had a reason to go into his cell, and they were looking for a shank there. And it's also true that they did find some what's called hooch, in other words, homemade liquor that the cell. But you're going to hear that it was actually the roommate's homemade liquor, cellmate, sorry. Cellmate's homemade liquor. And the cellmate, at one point on one of the tapes you'll have, says, yeah, it's mine. They come out and say, who wants to take responsibility for it? He says, yeah, it's mine. So it's not this defendant's who's in trouble for having homemade liquor in his cell. But what I want you to note is that as they're searching his cell, he's not hostile to them at all. He walks out of the cell, takes his tablet, which is something he can use to read on, and he's just standing there.
It's an iPad. Show us the video. This is good video. Body cam video. High definition. Ooh, there's a mop. That's dangerous.
Then, you're going to get from the body cam figure, they claim they found a knife. But what you'll really hear is that they found a plastic knife. And they seem to be disappointed at that, because then you hear them say, and it's real soft, but you'll hear it, well, there's got to be something in here somewhere. Meaning, they were going into the cell looking for something to get these folks in trouble, not really to go after a shank, as they claimed.
Here's a stereoscope.
Found a knife. Gotta be something.
There's gotta be something.
Then what happens is they take the pillows from these inmates. And you'll see, even while that's going on, I want you to watch the video in this corner here. My little lighter works. In the corner, that's him standing here. You'll see, he's still standing there quietly. And the pillows are not contraband, but they're taking them anyway, because they are harassing him and trying to provoke a reaction from him.
Pillows are not contraband. That cell looks like a mess. I mean, there's stuff everywhere.
Now,
wow.
What happens next is that Mr. Thomas starts to complain. And yet, he uses some colorful language and some words that even I won't repeat.
We'll hear him, though.
And there aren't many, but this is a couple up there. But you will hear that it is a lie, a flat lie, when these officers say that they took their fans because they were somehow contraband. Rather, what will be very obvious from the evidence in this case is that they took his fans because Mr. Thomas said, I want to talk to a supervisor, he complained about it. And let me be clear about something, it's context, because it sounds like this is a dispute over a little fan. You saw what those cells are like, and you saw what that place is like. Prison is not air conditioned. This is July. So having a fan in your cell is actually a really big deal for these inmates. And the guards know that. And you'll hear that they are taking his fans to punish him for daring and having the audacity to speak up and complain about what was going on.
They took his fan, and it was, there goes the other one. They didn't look modified at all.
And just in case that's not clear what's going on here, you hear from another officer that say, hey, they're going to run their mouths, F it, we're going to take their fans.
Keep talking, I'm going to take your fan. Say one more word, I'm taking your, okay, take his fan. Hey, look, y'all give me a call on this block, bitch. Now, how about that? Look, nigga. Look, nigga. Give me that one, too. They want to run their mouths, fuck.
Mr. Engel, you have about 5 minutes remaining.
So here you'll see a close-up of what's going on there. All that's going on. You'll see him standing there. Now, the defendant asks him to cuff up because he gets upset and he knocks over that water cooler. And they say cuff up. And he says, can I get a white shirt in here? In other words, can I get a supervisor because they're taking my fans, they're violating my rights, and I want to complain about it. And these officers will know that if he gets a supervisor in there, they could be the ones who get in trouble because they have violated all the rules they have. So they can make more of a situation.
Get a white shirt, nigga. They get a white shirt, nigga. Took my motherfucking bag. Get a white shirt. Get a white shirt. Don't take my hand, bro. Took my hand.
Oh, man. You got triple
Spray in
sprayed.
the face.
Get a white shirt. Don't take my hand, bro. This is your final directive. This is your final directive.
His hands are behind his back.
Now,
But he waited until the last minute.
if you read their reports, will be from the officers, is they'll say he ignored multiple directives. I gave a final directive to cuff up he didn't comply to. He violently attacked all three officers, hitting all three officers, and he pulled his pants up, displaying what you heard called pre-assault indicators. Well, let's look at what's actually going on here. He's got his hands out.
I like the four screen.
He's not complaining. And when they actually spray him, see this moment here in the bottom left, his hands are behind his back. He's actually complying when he does it, but they spray him anyway. And then he runs away, goes into the corner, and it gets worse because what's described as a struggle, you'll actually see on the video, are these corrections officers and others pulling his hair and beating him. You see it here. And you'll see it another thing here.
They're wailing on him.
And what you'll see are not what's sometimes called compliance strikes, meaning you're trying to hit someone to get their attention so that they pay attention and they comply and do what they want them to do. But what you're going to see is, especially this officer here, beating the defendant multiple times, just hitting him in the back of the head. You see other people hitting him in the back of the head. You'll see an officer here trying to actually hit him, and all you see is like a Muppet. He's just kind of hitting into the air, trying to hit him, not trying to get any compliance.
Muppet officer.
And then you'll see they actually spray him with pepper spray right into the eyes. And
Use your hands! Use your hands! Hey, get over here, Blake! Hey, you hit me first! Thomas, give me your other hand now! Hey, it's nothing! I can't breathe!
And that comment, "I can't breathe," is Mr. Thomas after he gets sprayed right in the face again with pepper spray.
Wow.
So what are you going to look for in the evidence? You're going to look for, did the corrections officers create this situation and provoke them? Did they act consistent with their duty to de-escalate the situation? And then they use excessive force afterwards as they're trying to get him in handcuffs? What you'll also hear is that the Highway Patrol has got all those videos. They've got that video of people beating this guy in the back of the head. They've got those videos of threatening to take his property, even though all we wanted to do was ask for a supervisor to come here. They'll have evidence of a lot of misconduct by these police officers. But what sort of investigation is done by the Highway Patrol of that? Nothing. That's what you'll hear. This is all an effort to cover up for misconduct by these officers. And Mr. Thomas is going to testify. He's going to sit in that stand right there.
Oh, he's taking the
He's going
stand.
to tell you what life is like in there. He's going to tell you that he had some mental health issues, and he was on a mental health caseload, and they knew about that. And they were taking advantage of that to try to provoke him. They created this situation. Mr. Thomas, when he's surrounded by folks who are trying to beat him, has a right to defend himself. And Judge Oda will instruct you on the law of that. So I thank you for your time. Mr. Thomas thanks you for your time and your attention on this job.
Ms. Trainer, call your first witness.
Thank you,
Wow.
Your Honor. State calls Kevin Chamberlain.
I was not expecting this case to be as intriguing. Whoa, a little bit of a seizure happening here. Sorry about that. Somebody's unplugged something.
Thank you, Brittany.
Ms. Trainer, are you going to need your laptop for this part or the...
Let me just make this copy full screen. They need to fix this.
Probably not, but just in case, I'll hook it up.
So we all go into a... There we go.
Started going creepy when Mr. Engel disconnected.
I am disconnected. So
I'm just turn the TV
I
off.
don't like doing that.
Sir, do you swear from the testimony you've given in this case to be the truth, the whole truth, nothing but the truth, so help you God?
I do.
All right, let's eat up here.
Okay. Good morning, sir.
Good morning.
We're still at morning.
Yeah.
All right. State your name, please. Spell your name for the court reporter.
Kevin Chamberlain, Chamblin.
And how are you currently employed?
Investigator,
Okay. Investigator for who?
Warren Correctional Institution.
Okay. And how long have you been with Warren Correctional?
About 25 years.
Okay. And been an investigator the whole time?
Nope, I've been an investigator since about May of 22 till present.
Okay. What did you do prior to becoming an investigator?
I was a corrections officer for about 13 years, lieutenant for about 6, and then gang coordinator, and then I moved over into this position.
Okay. How long did you say you were a corrections officer?
About 13 years.
About 13 years? Okay. Your whole time was at Warren?
Yes.
Okay.
Food
And
Lion? They have them. Food Lion has them.
tell the jury about a little bit about what your duties entail now as an investigator.
So we conduct mostly administrative investigations. We also are liaisons with the State Highway Patrol and other stuff. If stuff becomes like a criminal matter, then we contact the State Patrol so they can be brought in and to do their stuff.
Okay. Tell us what you mean by administrative investigations.
Administrative investigations, possibly dirty staff, EEO investigations, that kind of stuff.
Okay. So you mentioned the Highway Patrol. So when something happens within the prison that kind of crosses the line there between administrative and criminal, that's when you call in the highway patrol, right?
Correct.
Okay, tell us about the prison's relationship with the highway patrol. You guys have certain investigators that are assigned to your prison, correct?
Correct.
Okay, and who are your investigators?
Well,
yeah, it's changed,
It's
right?
changed.
That
It
was a
changes
bad
every-
question. So let's go back to July of 24. Who were your investigators in July of 24?
The Trooper Clance.
Okay, and he is no longer in that position, correct? Because he's moved on to other things, right?
Correct.
All right, but at the time of the incident we're talking about, Trooper, now Sergeant Clance, was assigned to the prison. Okay. Are you familiar with something called the Rules Infraction Board?
Yes.
Okay, tell them what the Rules Infraction Board is.
To sum it up, basically, it's like court for prison. Inmate gets a conduct report. It's severe enough that it needs to go on past the sergeant's level. They refer it to RIB, and it's basically court.
Okay. And
Not
is
gonna
that
count
a
okays.
situation that
Not too
happens
many.
only when there is a criminal incident involved?
No, it can happen in other incidences that are harsher in nature.
Okay. And how is this board, who is it comprised of?
They will have a lieutenant, would be the RIB chairman, who would serve as the judge, and then they have another person that would sit on the board or sit next to them to hear the conduct report case. That could be any other staff member.
So 2 people?
Yes.
Okay. And what does the process look like?
They get the lieutenant gets the case referred to RIB, and they have obviously certain documents they need to go over. And then once the case comes up to the RIB to be heard, they bring the offender in and they go over the rights when it concerns RIB. And then they go over if they want any witnesses, they want the charging official, and then they go over the body of the conduct report, and then the inmate can offer a defense as any other information that seems that he's not guilty of it. They go ahead and go over everything, including other possible video evidence, any other evidence that goes for the case, and then they go ahead and basically render a decision.
Okay, so just like court inmates have an opportunity to testify, bring in witnesses, or any other evidence that they choose to do so, correct?
Correct.
All right. And it's the board, the lieutenant, you said, and one other staff member that issues the decision, correct?
Correct.
All right. And what are the consequences of, say that the board finds an inmate is liable for during an RIB hearing or guilty? What are the then consequences?
It could vary greatly to, they could either find him not guilty or verbal warning, all the way up to increased security level.
Okay. All right. Can you give us just some general information about Warren Correction Institution? Like, how's it set up?
Warren Correctional Institution is a state-run correctional facility. It houses basically 4 levels of security inmates, 1s, 2s, 3s, and 4s, including death row. The majority of the population is level 3 population. The buildings are set up in more of a dormitory or a dormitory with cells. Each unit has two ranges in it. We house approximately, at this current time, about 1,000 inmates.
Okay. Level 4 being the highest level of security?
Correct.
Okay. What is an inmate's security level based upon?
Basically based upon their prison record. If they get found guilty of some rule violations that constitute a threat of security or safety, they can usually stay. Usually those are the 3s.
So is it fair to say that their security level is fluid, can change at any given time?
Correct.
Okay, based upon their behavior and rules, infractions, that kind of thing?
Correct.
All right. Do you know how many COs at least at the time of this incident, how many COs were employed?
We stay right around 200.
200
Ohio.
COs
Warren County,
for approximately 1,000 inmates?
Mm-hmm.
Okay. Is there a state ratio or anything that has to be abided by?
So we have a TO. It's around 250, 255. Although due to with the hiring issues and stuff like that, it stays around 200.
Okay. All right. Tell us about are there certain areas of the facility designated for certain things? For example, like is there based on security levels or any other classification?
I got you. Like I said, the majority of them are level 3s. That they are usually in the housing units. Our level 1 and level 2 inmates have a dorm away from the level 3 dorms on top of the hill. And then our higher security, we have the 3 high security units that includes the mental health unit and then TPU or segregation as well.
Okay. Tell us about the mental health unit.
Mental health unit is a the term is residential treatment unit. Basically, we have on medical or mental health professionals, including a couple of doctors, that monitor and deal with mental health needs of the inmates.
Okay. And approximately how many inmates are housed at any given time in that unit?
The higher security unit is about 30. That's where they have mostly 3s and 4s in there, and that's where they have, I think we only have 1 death row inmate right now, and then the other unit holds about 60 other inmates, or typically they're level 3 mental health inmates.
Okay. And how is it determined if somebody gets housed in the mental health unit?
I'm not real familiar with that, although I do know that it's somebody from the mental health in Columbus. The support center is the ones that actually probably do the review and then make the recommendations because of very limited bed space on who they can let into that unit.
Okay. Is this something that happens kind of on the front end when a person gets admitted into prison?
It can, but it also happens while they're incarcerated because things do change during the course of their incarceration, where they do end up in the mental health in the unit, one of the units.
Okay. Can an inmate request to be in the mental health unit?
They can, but it's very, very hard to get into that unit. There's a lot of stuff that goes on from the mental health aspect and policy procedures and stuff that it's hard to get in. It's hard to get in there.
Okay. So a mere request to go into the mental health unit does not necessarily mean that they're going to be moved into that unit?
Correct.
Okay. Is there a review process when an inmate requests that?
I think there is. I think that they would do is they would send a request up or a kite to the mental health asking about it, and then they would probably interview them and try to see if they meet their criteria for that.
I'm going to back you up because you used a term that the jury probably is not familiar with. You used the word kite. Yeah. Can you explain what that is?
Kite is basically like an email or a letter within the prison system that they can send to a particular department, sometimes a particular staff member, and basically asking a question or have a concern that they want to bring up.
Okay. They meaning the inmates?
Yes.
Okay.
Sorry.
All right. And how do they do that?
If all else fails, they can do a paper kite, but typically it's going to be on every unit has a kiosk or an area or a tablet that they have access to send it. But outside of that, every inmate is issued a tablet that has access to that on that device.
Okay. And is there probably going to use the wrong term here, so forgive me, but is there what they say, an app for that, right? Is
yes.
that a direct link?
It's on the tablet or the device.
Okay, gotcha. So every inmate has access to either through a tablet or through their own kiosk has access to be able to send a kite at any time. Is that fair?
Correct.
Okay. All right. Are there cell searches that ever take place at WCI?
Yes, daily.
Daily. Okay. What's the purpose of a cell search?
Cell search is to basically check the cell for contraband, other security issues, sanitation issues, stuff of that nature.
Okay. And are there guidelines in place that provide for when a cell search can happen?
Not so much when, but each officer, I believe, currently they're required to do 2 cell searches per shift. They do track it so that every cell gets searched within usually within a week. And the criteria and information concerning cell searches comes derived from the policy. And then that is also information is in the post orders that the officers sign for, saying that they understood that and reviewed that every day.
Okay. So they have to perform, you said 2 per shift?
Each officer is 2 per shift.
Okay. And are those selected at random?
They can be at random or for any reason, really.
Okay. For instance, if they receive a tip that somebody might have something they weren't supposed to?
Correct.
Okay.
We are going to do an officer safety counter. Can you guys keep me honest?
All
Just
right. So
post the number if you hear
you said that there
reference to
are
it.
procedures in place for how to conduct a cell search. Okay.
Yes.
Tell us about that.
So every officer, when they come in and they get trained on cell searches, on how to do a cell search, different levels of cell search. They're looking for minor contraband or major contraband, et cetera.
Okay. What's the difference between major and minor contraband?
Minor contraband could be a paperclip. A major contraband could be weapons, drugs, homemade alcohol, or cell phones.
Okay. And is there differentiation of the consequence that follows when somebody possesses a major versus a minor contraband?
Yes, obviously the major contraband is deemed more of a security issue, so therefore the penalties for having that is a little more, could be more severe.
Okay. All right. Do inmates ever get upset about their cells being searched?
Yes.
Okay. And do they ever get upset about items that are confiscated during cell searches?
Sometimes, yes.
Okay. And is there a process that is in place for them to protest items that were taken that they believe should not have been taken?
Yes, they can get a hold of the unit sergeant who's here's like a conduct report for the property, or they can submit a kite and or informal complaint, which is another message. It's a more formal message to either that supervisor or the inspector who handles the grievance process.
Okay. And how is that procedure made known to the inmates?
Every inmate when they come through orientation, they actually have the inspector speak to let them know about the grievance process, and I'm pretty sure it's also in an inmate handbook that they know how to access that system.
Okay. Is that again something that's accessible on their tablets or their kiosks?
I know the handbooks are in every unit, and they're accessible. But yeah, the grievance process is accessible through their tablets through an application.
Okay. Now you made reference to a unit sergeant as being another alternative for them to protest something. Mm-hmm. Tell us about that.
Every unit has a unit sergeant. They are responsible for sanitation and cleanliness of the unit. Also, they hear conduct reports. And then that also part of the many duties that they have is when it comes to property issues. If an inmate does have a property issue, if the inmate wants to go ahead and grieve it or they have an issue with it, they can contact the sergeant. The sergeant can take a look at the property. If they deem that the property was unjustly taken, they can possibly return it or keep it, and then depending on the property, refer the case to RRB.
Okay. And is that something that's done through the kite system as well?
It can, but as unit sergeants, they can send them a kite, but the unit sergeants overall generally have a set schedule that they're required to be down in the housing units, so they're down in the unit several times of the week during the week that they'll be able to be contacted.
Okay. So
in person.
They could just go to them right out. Okay. Is there a unit sergeant, you said several times a week, so there's not one there on like a 24/7 basis?
Correct.
Okay, so they're there on a set schedule.
Yep.
All right. So, if somebody wants to talk to a unit sergeant about something and they're not present, what's the proper procedure?
They're just going to have to wait. If they're just not there, then they're just going to have to wait. They don't really, inmates can't, they can request a supervisor, but they don't have the right to a supervisor whenever they deem, or else supervisors may be down in the units all the time.
All the time?
Yeah.
Okay. Sorry, I was going to ask you something else about that, and it went straight out of my head. So we'll come back to that. What does the term white shirt mean?
White shirt is basically a supervisor, lieutenant or captain.
I remembered what I was going to ask you. Do you have an estimate on how long a grievance process review would take?
They have 7 days to render an answer.
Okay.
And then if they disagree with that answer, they can send it on to the next level to a grievance. And then the grievance is handled by the institutional inspector, who then has another timeline to answer that one. And then if they disagree, they can also appeal that decision, and to have someone from basically central office that oversees the inspectors to review the case.
Okay, so several levels of appeal.
Correct.
And the first one has to be addressed within a week, you said?
Yes.
Okay, so not like it's going to sit on somebody's desk for a month without
Correct.
being addressed.
Correct.
All right. Okay. Are you involved in any of the grievance process reviews?
I am not.
Okay. Are you aware when they're filed?
No, I don't really get notified of it. I mean, I could check and look, but it's not really within the scope of my job duties.
Okay. And did you have occasion to check during this instance to see if Mr. Thomas filed any sort of grievance?
I did not.
You did not check?
They did not check.
Okay. All right. So let's now turn to the date in question, which is July 23rd of 2024. You were in your current capacity at WCI on that time?
Correct.
Okay. And you said Sergeant Clance was your investigator?
Correct.
Okay. In July of 2024, were you familiar with Mr. Thomas?
Yes.
Okay. Do you know how long he had been an inmate at the time?
A couple years. I think actually he came to WCI in 2019.
Okay. And let me ask you this, is it common for you to know an inmate by name or face?
I try to know as many inmates as possible, but obviously the ones that they may be involved in stuff, that the ones are the ones that I'll know more obviously about, because I've either had their cells searched or I've reviewed things about them, whether or not be included in the possible gang activity and other nefarious activities inside the prison.
Can we approach your Honor?
I'll sustain the objection. Ladies and gentlemen, you're to disregard that last portion of the answer. The fact that Mr. Thomas may be incarcerated, the fact that he may be known to these people, your duty is to determine what happened on this particular day, what happened before, people's character. That is not to be used in any way to assume that it is more likely that they acted in a certain way on this occasion for which he is charged. Let's move on from this, Ms. Trainer.
Yes, Your Honor. Do you know where he was housed on July 23rd?
Yes, it would have been 3 Bravo.
Okay. And what does that mean, 3 Bravo?
It's a general population housing unit.
Okay. So your housing units are designated different names, correct?
Yes, so that they can be identified for location purposes and housing purposes.
Okay. And you said it's general population?
Correct.
Okay. And how many levels are on 3 Bravo?
Security levels or like the
Like physically, how is it made up?
It's got a first and top 2 stories.
2
basically.
stories,
Yep,
okay.
2 ranges.
All right. And what does a typical day look like for an inmate that would be housed in general population on 3 Bravo?
So first thing in the morning, they do count around 6 a.m. They get released, and sometime within the next couple hours, they'll be released to go to chow. Every unit is escorted at a particular time, so it's organized, and they get everybody fed. And at some point during the day, they will get the opportunity to participate in recreation. And then noon is lunch. They have a count mid-morning, count in the afternoon around 3:30. And then dinner after that, and then lockdown is about 9:30. It's at 9:30 at night for the final count, but they do have intermittent ranges out in the day rooms, go on passes, go on different stuff that they've got going on throughout the day.
Okay. So they're on a pretty set schedule.
For the most part, yeah.
For the most part. All right. And back in July 2024, were you familiar with Officer Owen Sycamore?
Yes.
Okay. Do you know where he was assigned at that time?
He was assigned to 3 Bravo.
Okay. And how about Casey Bromine?
He was also assigned to 3 Bravo.
Okay. And you knew him as well?
Yeah.
Okay. And Officer Jesse Blythe? Do you know him?
Yes.
Okay. And where was he assigned at the time?
I believe he's actually assigned to the housing unit right next to a 3 Alpha.
Okay. All right. So at some point through your employment, did you become aware of an incident that occurred between those 3 officers and Mr. Thomas on July 23rd?
Yes.
All right. Tell us how you became aware of what happened.
I was in a group text for notifications when it comes to certain incidences that happen about the incident.
Okay. So you were not on property when it happened?
Correct.
Okay. Do you know what time of day it occurred, approximately?
After evening.
Okay.
Evening. I'd have to check to make sure exactly what time when it happened. I think it was in the evening.
Okay. Do you work like a regular 9 to 5 schedule, or?
For the most part, yes.
For the most part?
Yeah.
Okay. So fair to say it happened after your shift had ended for the day?
Correct.
All right. Okay. So what information did you initially have about what happened?
Basically, there was a staff assault. Basically, who was involved, what was the steps being taken immediately after the incident, that stuff. Pretty much just cut and dry the basics of what happened.
Okay. And when you are in a situation where you're dealing with a staff assault, is this something that falls within your capacity as an investigator to investigate?
No, I wouldn't do the investigation. The conduct reports and stuff like that would be involved in that would be, obviously there's already a process for that. But being possible criminal matter, I would contact OSP.
Okay. Now, is that what you did in this situation?
Correct.
All right. Okay. Tell us what a conduct report is.
Conduct report is basically it's a ticket. Is basically how I put it.
Okay. What does that mean?
It's like a parking ticket or a citation. Basically, it's a accusation with a set of rules that you can select from for the possible violation to be charged, and then that gets electronically submitted, and then it goes through the process through basically the RIB process if it gets to RIB or if it's heard at the sergeant's level and closed.
Okay. So there was a conduct report issued for this particular incident?
Yes, I'm sure there was.
Are you the one to issue that, or is that somebody else?
In some cases, I would have to check. In some cases, I would do the conduct reports. In this case, I don't recall that I did.
Okay, fair enough. And there's video surveillance, obviously, at WCI, correct?
Correct.
Is that part of your job to maintain that and through the ordinary course of business?
Yes, when incidents happen, go ahead and get the dates, times of the events, and then go ahead and download those videos. They get sent to our server, and then I pull it from the server onto typically a flash drive to give to the State Patrol.
Okay. And the officers who work within WCI have body cams as well, correct?
Correct.
All right. And same thing, is that part of your job to maintain those body-worn camera footage?
Yes, for not in general, but for incidences, yes. I would get those body cam footage and get them shared with the troopers.
Okay, I was going to say, sure, with OSP who does the investigation, correct?
Correct.
All right. Okay. Let's talk a little bit about the policy for use of force at WCI. Is there a policy and procedure in place?
Yes, there's a state policy that every institution adopts and trains on.
Okay, and that's through the Ohio Administrative Code, is that?
Yes, there's 63 UOF and then the 5120-9-01. And
Okay.
there's sub parts like 02 and 03, but 01 is.
Okay, and this is like a general statement of procedure and policy and law that all prisons in Ohio are expected to follow?
Correct.
Okay.
This is interesting that they decided to
tell us
pursue this
what,
charge.
as far as being in a correctional setting, what is the difference between deadly versus less than deadly force?
Less than deadly is the most common. It covers a lot of different ranges as far as circumstantials. Deadly force is very specific and thankfully not hardly ever used. So, and where basically with deadly force, whatever your actions as a staff member could likely cause the death or serious physical harm of an incarcerated person.
Okay. Are you familiar with OC spray?
Yes.
Okay. Tell them what that is.
The technical term is OCM capsin spray. It's basically pepper spray. It's every staff member gets issued it.
What, so when COs are on duty, they carry OC spray?
Correct.
Okay. What is that considered when an officer has to deploy OC spray? Is that considered a use of force?
Yes, it's kind of considered the lowest level of force because there's never really any permanent damage.
There's
and it's usually
never.
They would rather them use that before trying to go to physical force.
Okay.
So why would you be beating on
What
the
do
guy
officers
and
carry
spraying?
during their shifts?
Keys, cuffs, radio, pepper spray. Most officers have a belt, a duty belt, body-worn camera. Generally speaking, maybe a little pouch with some gloves in it, so a flashlight.
Okay. Do they carry any sort of baton or anything?
No, they do not.
Okay. Do they carry a gun?
No.
Okay. Do they carry anything aside from the OC spray that could be considered a weapon?
No.
Okay. And is there a particular policy or procedure that is listed for the use of OC spray?
It would fall underneath the use of force policy.
Okay. And are you familiar with the term pre-aggression indicators?
Yes.
What is a pre-aggression indicator in a prison context?
Pre-aggression indicators can also be viewed as a possible pre-assault indicators, aggressive behavior, aggressive physical stance, words, that kind of stuff.
Okay. Can you give some examples? You said words. What?
Yelling, highly agitated words, maybe the words that they're saying or threatening, clenched fist, pacing, different stuff of that nature.
Okay. Officers are trained on those?
They are trained through the use of force policy about obviously potential pre-assault indicators, what to watch out for.
Close to officer safety.
Okay. And why is that important?
Here it is.
It's important so that, you don't get assaulted, right? Try to maybe see what something could bad be getting ready to happen, so that you don't get assaulted.
Said it twice.
Okay.
Count it. Officer safety. We're counting the number of times that's mentioned in this trial.
When there is a use of force incident in the prison, whether it be OC spray or some sort of other physical altercation that happens, what happens after on the back end of that?
So every use of force is documented.
We get issued a new OC spray.
A bunch of stuff that needs to be done. Once the packet gets done and reported, it gets submitted to the major and deputy, and who they review it, and then they determine. Then it goes to the warden, and then they decide if it needs to go to committee, which basically means that there's going to be another review, a more one-on-one type review of the case, and then that chairperson, like I said, goes over all the evidence, conducts interviews, and then makes a determination if the use of force was justified and appropriate.
Is an officer required to fill out a report for every incident, every use of force incident?
100%.
Okay. Does that include OC spray?
Yes.
Okay.
Using OC is force.
Okay. And that's just part of the process, right? These reports are filed.
Correct.
Okay. And does every filed report end in a hearing?
It gets reviewed. It gets reviewed by the major and the deputy. Not everyone gets sent to committee.
Okay.
If they've got questions, if the managing officer has questions about what happened, then yes, he will send it to the committee, which is basically the final step and final investigative review.
Okay. And the major and the deputy are people that would have had no involvement on the front end with the incident, is that correct?
Correct.
Okay, so kind of an independent review, for lack of a better word. All right. Hypothetically, if a report is filed, the major and the deputy review it, and they determine no unnecessary or excessive use of force, right? Mm-hmm. What happens at that point? Is the officer made aware of the decision?
If it doesn't go to committee and they say it's legit, it's completely legit, they don't require to let the officer know that it was done. Now, if it's not, if there's a question about it, then yes, they will know about it, but not if it's been legitimized.
Like closed out and
Correct.
No further action taken, right?
Correct.
It's only if it goes to a hearing to committee that the officer would be notified.
Correct.
Okay. Okay, I do not think I have any further questions for you. Well, I'll ask you this. Warren Correctional Institution located in Warren County, state of Ohio?
Correct.
Okay, I have no further questions for you at this time. I'll pass it to Mr. Honor.
Mr. Ingram, you may inquire.
Thank you.
Let's see if this gets interesting here.
May I approach?
You may.
Thank you.
There's a copy for you and a copy for you. These are the list of inmates' rights. Give me my copy. There you go. You all have a copy. You didn't grab your copy. You left it at the desk. Stickers on the laptop. Bold choice.
Yeah, barely after.
Yeah.
It's 12:10.
So it was your job to review the evidence in this case, right?
Correct.
And part of the reason you do that is you're looking for any policy violations.
So I gather the case to get it ready for the patrol. I don't really conduct an investigation with it.
So do you have a role to play if there is misconduct by officers?
Not necessarily, because there's already a procedure in place. Obviously, if there was something that happened that I seen, I would have to report that. But there's already the incident is already being investigated because of the use of force. There's already a mechanism in place to determine that.
So the highway patrol is doing that, right?
No, so the prison would do it because they've got a position in place to conduct a review of it. The patrol would obviously, if they get presented to something that there is a violation in there that they need to address, they will address it on their end.
So what would you do if you saw a violation?
I would report it to my superiors.
Okay. And do you review, so you review the use of force reports in this case?
I get them. I gather them. I don't necessarily have to review them. Like, I gather them because there's a packet done. I get the packet, and then I send it to who. In this case, it would have been the State Patrol. So I would get the packet and send it to them.
So let's drill down. In this case, did you gathered the use of force reports?
Correct.
Okay. And all the officers involved are required to fill one out, right?
Correct.
Did you read those?
I glanced over the front page to get the gist of it, but I wasn't required to read everything because like I said, I'm not the one making the determination.
So the answer is no, you didn't read them.
Correct.
Okay, so you, as the investigator for the prison, well, let me back up. You gathered all the videotapes too, right?
Correct.
So the surveillance tapes from the sky cameras, and then the individual body cams?
Yes.
Did you review those?
Yes.
Okay. And did you compare the videotapes to the statements of the officers in the use of force reports?
Again, it's not my responsibility to do all that. Like, there is a use of force.
I don't care whose responsibility it is.
Right.
I want to know, you're the one who's testifying.
Yeah,
I just want to know what you did.
No, I did not. No.
You did not?
Nope.
So you never checked to see whether the use of force reports were accurate or not?
No, nope.
And you never checked to see whether the officers involved complied with all the policies involved?
No, I did not.
Okay, but you did testify to some of these policies. Let me ask you about them here. So if you look at tab A in your binder, there's something called a policy for searches of cells, right? We've stipulated these exhibits, I believe. And so this is policy from ODRC about searches of cells, right?
Okay.
And you're familiar with that policy?
Yes.
Okay. And in the court, and so as you tried to investigate this matter, you reviewed this policy to make sure that everyone's complying with it, right?
Again, I did not investigate this.
Okay. But you did indicate that, well, I'm just trying to figure out what work you did. You're the investigator, right? And you gathered evidence here.
Right.
Okay. Did you gather and put in the packet of information this search policy?
No.
Okay. Now, you indicated that each officer is required to do a number of searches each shift?
Correct.
Okay. So that's they have a quota for the number of cells they're supposed to search? Do they also have a quota for the amount of contraband they're supposed to find?
No.
But each cell is then supposed to be searched one time a week.
Correct.
Okay. So you would expect if there was something illegal in the cell that it would be found every week then, right?
Hopefully, yes.
Okay, hopefully, especially if it's something big, like say a pillow, right?
Theoretically, yes.
Pillow's right there in plain sight, you would expect that it would be there, checked every week and wouldn't be in the cell for more than a week, right?
Correct.
Okay. And same with a fan, right? If there's something wrong with a fan, it wouldn't be there for more than a week because someone would see it right away.
Correct.
Okay. I mean, these aren't items like, sometimes you might be able to hide something, right? People conceal things all the time, right?
Correct.
Okay, sometimes they put things behind mirrors or under the bed or something like that, right?
Yes.
Okay. And so this search policy says, can I blow this up? The one that's a Zoom Plus, I can do it.
All right, there we go. Now we can read. Searches of cell houses or housing units.
Okay, so what's supposed to happen is during a cell search, the individuals are
Love
to
the
remove from the
tabs.
cell, right?
Correct.
Okay. And here, I'm confused about something. The cell search occurred, it was after 9:30 at night, right?
It was in the evening. I'm not exactly sure the time, but
Was it after lockdown, do you know?
I don't recall. I'd have to check.
Well, let's roll the tape because we've got body cam.
Well, is there something you could look at to check when that might be? That's 9 o'clock. So what time is lockdown? You said 9 o'clock, 9:30?
9:30. It's a 9:30 count.
Okay. And so you guys often use military time, so 21:18, what time would that be?
21:30.
Okay, so that would be 21:30 would be lockdown. And are cell searches often conducted around the time of lockdown?
They can be. It's really up to the individual doing the cell searches when they can do it.
Okay. So now when we look at this policy again, it says that the search has to be systematic, right? That's point B. You're familiar with that, right?
Mm-hmm.
Okay. You're supposed to look at fixtures, beds, look for false bottoms, secret compartments, right?
Correct.
He says,
It says reasonable care shall be taken during the search so as not to damage or destroy cell contents or fixtures. What's the point of that?
You want to treat the inmate's property with respect.
Okay, why is that important?
Because we're not there to punish them. We're there to do a job, and you can do a cell search without destroying the property. Now, obviously, if it's something that they need to seriously look for, then they can be a more in-depth cell search, which would require be going through the property more in depth.
So let me just be clear for the jury. Using a cell search as a punishment, that would violate ODRC policies, right?
Correct.
And if you found out or had information that a cell search is used as a punishment, what would you do?
If we could prove it, it could be subject to discipline.
If you discover during the course of your investigation evidence that a cell search is being used as a punishment, what would you do as the investigator for the correction?
I would notify my boss.
Okay.
Did you do
Now, you also, I assume you can't take property as punishment either, right?
Correct.
So same thing applied. If you discovered that property had been taken as punishment, you would notify your supervisor.
Correct.
Okay. So now, in this case, it says also a list of contraband and the location which was discovered must be documented, right?
Yes.
Did you ever obtain a list documenting the property that was taken out of Mr. Thomas's cell?
I did not.
Do you know if that even existed?
I do not know.
So can you sit here and testify that the officers complied with the policy, at least in terms of documenting what was done?
No, I can't.
Okay, did you notify your supervisors, like, hey, it appears that there was a violation of our policy here, so that someone could take corrective action?
I didn't because, again, it's not my job to review that part.
Okay, so but now that you're aware of it, right, what are you going to do about it?
Oh, I go back to work, I can report it.
Are you going to do that?
Yeah, I'll let my boss know.
Okay. And so.
Wow.
And the same. So as you reviewed these videotapes, did you discover any evidence that property was taken as punishment?
Not as punishment.
Okay. Now, you said inmates, if they believe that property is taken incorrectly, they can complain about it.
Correct.
Okay. It's not a violation of the rules to complain about it, right?
Correct.
And they can ask for a sergeant to come down?
So if it's during normal business hours, they can request it, but the sergeant, and same with the supervisors, they're not required to show up down there over a complaint like that because there's already a process in place to complain about that.
Well, let me break this down here, right? So the inmate thinks that the property is taken incorrectly. He can request that a sergeant come down, right? Let's stop at the request part, right?
Okay.
He's allowed to request it.
Yeah, he can request it.
Nothing wrong with that, right?
Correct.
And let me back up. If it turns out the inmate is correct and that the guards took property for an improper reason, there could be consequences for the guards then, right?
Yes.
Okay, they could be reprimanded,
Discipline.
They could be disciplined in some way, put on suspension, something like that.
Correct.
Right? So the guards obviously don't want to be found to have violated this policy and to have taken things.
I'd assume so, yes.
Okay. So now let me back up. The inmate is allowed to request that a supervisor come down here. Who makes the decision whether the supervisor is going to come down?
So the inmate can request it. The officer can call them, but they're not required to.
But it's not, so just so we're clear, nothing improper about the inmate asking for a sergeant to come down.
No.
Okay, and the usual practice is the sergeant will then decide whether they want to come down.
Usually what would happen, so it would be a lieutenant or white shirt, because they're the ones that would be there after hours. We always have supervisors present, so it would be the lieutenant.
Okay, so let me ask a separate question, right? The inmate's allowed to ask for a white shirt or a lieutenant to come down.
Yes.
Nothing wrong with asking for a white shirt to come down.
Correct.
Inmate shouldn't be punished in any way for asking for a supervisor to come down.
Correct.
That would be a huge violation of ODRC rules.
Correct.
Okay. When the inmate asks for a supervisor to come down, supervisor can decide whether they want to come down or not, right?
If they are notified about it, they can.
Okay. So if they're never notified about it, they can't make that decision.
Correct.
So the guards have the ability to say, hey, we're not going to ask for a supervisor.
Correct.
Okay. Is that the best practice, or is the usual practice of the guards to say, okay, you want a supervisor to come down here, let's do that?
So it's a case-by-case basis, but the supervisors can't be just coming down to the housing unit all day long because the inmates don't want to listen to the COs for whatever reason. So it's not something that's done.
Okay. So it should be a major important thing, right? Mm-hmm. And I assume taking the property improperly from a cell, that might be an important thing.
Yeah.
Okay, that's not a minor dispute, right? This is actually something significant, right?
So when it comes, if you're asking my opinion, when it comes to the regular contraband, it's not major contraband. If it was serious contraband, then yes, the supervisor would be called because if it's a security issue, but not for pillows and stuff.
Okay. So, but part of it is, I think you said, because there is a process in place, right, for the inmates to complain.
Correct.
Okay, and that process, I think you testified to Ms. Tranter, takes about 7 days to go?
They can immediately, they can send it, and then they have up to 7 days to render a decision.
Okay, so if a fan, let's say, is taken improperly, inmate wouldn't maybe get it back for 7 days.
Correct.
Which is, in July, in an unair-conditioned place with no windows, that could be a big deal, right?
Correct.
Okay. So let me ask you then, and you have it on tab B, about the personal property of the inmates. And like I said, they're allowed to have personal property, right?
Correct.
Okay. Pillows are not contraband, are they?
Pillows are only permitted if they've obtained them through an official capacity, like a fundraiser.
Okay. And how would you know the difference between a pillow that's an official pillow and an unofficial pillow if you're searching a cell?
I mean, common sense, you could see that if there's a homemade pillow in there with the homemade stitching versus a pillow that was obtained through a fundraiser, which is obviously there's no issues with it. It's obviously pillows? Something that was purchased, not manufactured.
Okay, so pillows by themselves, not contraband, right?
They can be contraband.
But some pillows are, some pillows aren't, right?
Correct.
Okay. Same with a fan, right? Fans are not contraband.
Correct.
Okay. If you alter the fan in some way, that could be contraband. Then it can become contraband, right?
Correct.
So when you reviewed the videos in this case, did you see any indication that the pillows involved were contraband?
My opinion is that they were probably most likely contraband because of what they look like.
But you didn't know that for sure?
Correct.
You weren't there?
Correct.
Now, in the fans, when you reviewed the videotape, did you see anything in the fans that suggested they were contraband?
I believe the first one was missing the cover. and the second one looks like it may have had some damage to it.
So where in tab B does it say that you cannot have homemade pillows in the personal property policy?
I would have to go over this.
Yeah, take your time.
There's also another policy, 5120-9-55, I believe, is the Contra-ban policy that does actually state about the homemade.
Nothing in this policy here, right?
I can go through it, but I'm sure you've already went through it pretty good, so.
And then I want to ask you about tab C, which is the use of force policy, right? You're very familiar with that policy, right?
Sure, I guess, yeah.
Well, okay, so you're familiar with the term, let's make sure we're on the same page in some of these terms. There's a term called excessive force, right?
Correct.
Okay, and that's understood to be an application of force which by either the type of force employed or to the extent to which the force is employed exceeds that which is reasonably necessary under all the circumstances.
Correct.
You accept that definition? Okay.
Yep.
Then there's something called reactive force. What's reactive force?
Basically, it's the action, it's force where it reactions if you get assaulted or vice versa and you react immediately.
Okay, so it's supposed to be in response to an immediate threat of harm, right?
Correct.
And then you're supposed to do something called behavioral intervention too, right? What does that term mean?
Basically, you're trying to de-escalate it, de-escalate the situation.
Okay, de-escalation is important, right?
Correct.
Okay, and it's part of the policy too. Now, before I go through this policy, I want to ask you about something you testified to, pre-aggressive indicators, and you said these could be various behaviors, right?
Mm-hmm.
So you're trying to notice certain behaviors that could lead in the future to assaultive behavior.
Correct.
And some of that includes yelling, physical stances, words, right?
Yes.
Okay. Do those pre-assault indicators by themselves justify use of force?
No.
So just because someone is yelling, that doesn't necessarily justify use of force, right?
Correct.
So let me ask you about this use of force policy then. So first there's, is that me? I'm sorry. I thought my thing was on do not disturb. I apologize, Your Honor.
Sorry, I won't call him during trial anymore.
So, this use of force policy, part 6A, de-escalation and behavioral intervention, right?
Mm-hmm.
And it says that staff are required to de-escalate. What does it mean that you have a duty to de-escalate?
They want staff to try to de-escalate it so that it doesn't turn into a use of force situation or more serious situation.
And so little a under 1 says staff should attempt to communicate and verbally interact with the IP to avoid using force, right?
Correct.
So that would mean you're supposed to try to interact with them verbally and calm the situation down before you use pepper spray, for example.
Correct.
Pepper spray should be a last resort, not a first resort. Is that what you're saying?
It's, yes.
And so if someone isn't, for example, following your commands, you would try to find a way to get them to comply with commands before you sprayed them in the face.
Correct.
And it says staff are not expected to de-escalate a situation if it places them in risk of harm or physical injury. That makes sense, right?
Correct.
And then there's a section about should mindful to create physical space. Why is physical space important?
Obviously, the more space between you and the person you're dealing with, the more space, the less chance of being assaulted.
Okay, so if you have an inmate who's, according to this policy, displaying what you've called pre-assaultive behaviors, you probably might want to keep a distance from them rather than close that distance then, right?
Correct.
Okay. And you're allowed to bring in other people to help out too, right, in Part C?
Correct.
Right. So if a person says, hey, Supervisor X may be helped to resolve this situation, the staff is then required to call Supervisor X to try to de-escalate the situation.
Not required, but they would be more advised to do it.
Okay. And so when you say there's a duty to de-escalate, right, they have a duty to do that.
Correct.
So if someone asks for a supervisor, they have a duty then, as part of the de-escalation process, to get that supervisor in there to try to resolve the situation.
Ideally, yes.
Yes. Or at least make the phone call, right?
Correct.
I mean, a supervisor could say, no, I'm busy with something else, I can't come down, right?
Correct.
But then at least you've tried to comply with the policy, right?
Correct.
It wouldn't be consistent with the policy that just because the person asked for a supervisor, spray him in the face with OC.
Correct.
Same as this. And it's not the use of force policy, but I should ask, are you permitted to take personal property? Let me back up. Are corrections officers permitted to take personal property from an inmate merely because he asked for a supervisor?
No.
Are they permitted to take personal property in retaliation for them complaining about the way a cell is being searched?
No.
Mr. Engel, make sense to take a break right now, or it seems like we got a ways to go still, right? Or we're finishing up.
If it's okay with the court, maybe I spend 2 more minutes going through this policy and then
Okay.
take a break, if that works.
That works.
If it's okay. So I just want to spend this one other section while I got it up on the screen here. Staff created jeopardy. What does that mean?
Basically, it basically means just that the staff member instigated the incident.
And so number one, they're expected to maintain and display respect and professionalism, including to the incarcerated persons. Why is that important?
Because we're there to treat them like people. That's what they are.
Okay, and that's why number two is that they should never, that's an important word there, right? Never?
Mm-hmm.
Never verbally or physically provoke or abuse an incarcerated person.
Correct.
Okay. So how does that all fit together? Could that make the fact that you provoked an incarcerated person make the use of force appear to be unreasonable under the circumstances?
Possibly, yes.
And it's something you would consider as part of your investigator role as you looked at a use of force incident?
Again, I would not be conducting a review of the incident. There was people in place already to conduct that review, and then if they found that they were in violation, that they could be subject to discipline.
Now, so one final question before we take a break. When they conduct that review, they rely upon the use of force reports, right?
They're supposed to rely on the evidence, the body cam footage, the video evidence from the units, the statements, see if there's any contradictory statements, and along that with the policy to see if there's any violations by the staff members.
So it's important that the use of force reports be 100% accurate and document everything that happened.
Yeah, correct.
They shouldn't leave out anything that happened.
Correct.
Okay, and my lawyer's spidey sense tingled here for a second because he used the word supposed to. Is it the case that sometimes they don't actually review all that evidence and they just rely upon,
So I can't attest to how other people that conduct the reviews for the use of force investigations. I can't attest to what every one of them do, but they're supposed to do that.
Okay. So you don't know if anyone actually reviewed the videotapes that you gathered?
No, I don't. I don't.
It's a good place to stop here, if that's okay.
All right, ladies and gentlemen, we're going to go ahead and break for lunch. Remember what I've previously told you. You did not know enough about this case to begin thinking about how it should be decided, nor do you know enough about the case to talk about amongst yourselves. We're going to come back at 1:30, and like I said, if you want to talk about things not related to your jury service, obviously you can do that. If you want to go to lunch together, that's fine, but make sure that you don't talk about the case, do any investigation on your own. See everybody back here at 1:30.
Wow, this little case snuck up on us. Found it out of nowhere. Thanks for the tip, whoever gave us this. This is happening live, by the way. This is not one we can go back and watch on replay without a little bit of work. I find it interesting because right now, I'm still eating my lunch, sorry. Right now there's another case, what is it, New York, upstate New York, that is about that's addressing some officers' potential wrongdoing. And that case, they're only allowing the openings and closings to be shown.
We
This
are on the
one-
record outside the presence of the
one we get
jury.
at all.
We have a couple of issues. Mr. Engel, you made an objection, wanted to approach, I think when we were sort of talking about bad character evidence with regard to Mr. Thomas. Anything additional that you want to say about that?
No, the court sustained my objection, so.
Okay. We also gave the jury a cautionary instruction on the issue of character evidence. Anything additional from the state?
No, Your Honor.
Anything from the defense?
I just want to clarify, and I know Ms. Tranter would never do this, but this issue's being argued, I think, in the Supreme Court next week, about when there is separation of witnesses, that they should not be contacted or speaking with counsel, too, about the types of arguments and evidence that's been made in the trial as well.
I mean, I think that issue is being argued right now, but Ms. Trainer, we're not going to talk to the witnesses while they're in the middle of their testimony, right?
Of course not, Your Honor.
Okay.
And I'm clear, Ms. Tranter would never do that, I'm just creating a record.
I think there's an
Wow.
open question on that, but I don't think there should be, but I think there is, but, all right, so we don't have to worry about it. What else?
The other thing, I just want to clarify, because we're going to have a thumb drive with the body cam videos.
Okay.
Does the jury have a computer to play that, or do
They
we
will.
need to provide something? Okay, so I don't need to do that.
The jury will be advised that they will have the jury laptop, which is a laptop without internet access with which to play them.
Awesome.
So, also, the entire recording is going in, right, even though we may only play part of it in the courtroom? Is that right?
That's right, yes. We've got different body cam videos. I'll say that one of the body cam videos is 30 minutes long, because I think there's about 20 minutes of stuff that's irrelevant that happens before on the tape, on the video. The other videos are between 2 and 6 minutes long, I think.
Okay, Ms. Trainer, anything on that?
No, Your Honor, I've put all mine, the whole thing on it. I think you're referring to Officer Sycamores, right, where it's just kind of like
Yeah, it's
back
Officer
and
Sycamores.
forth. It's, yeah.
But the other ones are shorter, but I think my preference would be that they all go in a complete form, just so they have it.
All right, so make sure that we confer at some point between now and the time that we rest the case to make sure that the proper videos are all on the thumb drive.
Yes.
All right. So, Ms. Tranter, which counts, you have a draft of the jury instructions?
Yes.
Which counts apply to which victims?
1 and 2 apply to Officer Sycamore, and 3 and 4 apply to Officer Romine.
Okay, and verdict forms are on the chair next to Brittany's desk if you want them. Just a draft of the verdict forms. All right, well, I'll see everybody back here at 1:30.
Thank you, Your Honor.
All right, they're going to go to lunch. This feed will keep rolling. Our plan was to cover the Donna Adelson sentencing, but if we do that, we'll have to record this while that's going on, which is cool. We can do that. That's going to start at 3, so we've got, it's 12:30 now. They're coming back in an hour, and this case is intriguing. At first, it seemed like it was going to be an open and shut case. You know, assault in a jail. Obviously, there's a lot of witnesses. There's a lot of security, and cameras. But when you watch the cameras and the parts, especially the defense wants to show, I have questions. Yeah, well, I want to stick with this one. I have a lot of questions. We can go back and watch Adelson at another time if it's worth going back and checking out. But this seems on the surface to me that there was at least enough evidence here to support a suspicion or investigation into possibly some abuse of power by the corrections officers. Some of the comments that were made as he was down the hall, down by the wall, away from everybody, complaining about them taking his pillows, I'm like, come on. He's like, you're taking my pillows? And they're like, yeah, if you keep talking, we're going to take more. That's punitive. I think it's terrible and wrong. They ended up taking his fans, knowing that would get them. That's the one thing they really want during the summer. And now I'm not all about making prison extremely comfortable, right? It's not my. We don't need the prison to be like the Hilton. Your next stay at the Hilton is what the prison life is like. I don't think we have to do that, but it should be humane. It shouldn't be torture. It shouldn't be just it shouldn't be an environment that will create a boiling pot of tension among the inmates and between the inmates and the guards. I don't like this. And this is now the second case we've had out of Warren County where the prison guards, it's exposing a culture in the prison that is not pretty, and I don't think it's right. I'm surprised for that reason that the state took this to trial. The state has all this evidence. They know this is going to be brought up. This is going to be presented. It's not going to look good. It's not going to look good on them. Happy Columbus Day. Welcome. I know there are some courts that are not holding court today because of Columbus Day. There's also, I know that we have three. There are two competing holidays today. Depending on the vantage point, I guess you have on history. The Columbus Day is the first unofficially recognized one. 3 states recognize Indigenous Peoples Day instead of Columbus Day. 5 states recognize both Columbus Day and Indigenous Peoples Day side by side and celebrate them together. And 7 more states celebrate Columbus Day but don't give paid time off for that. So we'd have a split. So Indigenous Peoples Day, Columbus Day, all happening today. Welcome, and good we can still have court today. So welcome. All right. About 20 minutes behind. This is good stuff. This is a good case. It's also Thanksgiving in Canada. Yes. I hope Ian. I know he had some trouble with the generator. He headed up to the back 40, his acreage. And the generator wouldn't start. I hope he got that figured out. I didn't get to follow the result of that. Hopefully, I know there were a lot of people on social media that were volunteering to help and research and figure out how it starts. Ian, having about as much engine know-how and engine repair know-how as I have when it comes to makeup, we're both just completely lost. Wouldn't know what to do, where to start. Hopefully, he was able to get it resolved and get the power up there. In Europe, it's Monday, says Purple Coconut. Did anyone hear how Miss Runkle is? Last I heard, obviously this isn't my story to tell, but last I heard she had some tests done. It was fairly routine, but there's just some things they were watching for. Lebanon Correctional and Warren Correctional are right next to each other. They're always hiring for COs. I'm not sure if the turnover is that high or what. U.S. always seems to be on holiday. We don't have many in the UK. But you have like bank holidays, right? Just like bank holiday, generic bank holiday. What's with that, Emmy? I mean, it's cool. You get a day off unless you need to go to the bank. But Sheila in New York, thank you for the trial recommendation. This was great, Sheila. Thanks for pointing us to this one. This was not on our radar. This is a court we like to watch, but this was not on our radar. We were able to jump in just in time to get the opening statements and watch this one. We're going to watch this one through. And however long it takes, it looks like it might be a 2-dayer at least at this pace. Possibly 3, which means we're going to have to figure out how to go back to our Link trial, Florida versus Link, get it figured out. But let's see. Are we watching Adelson live? I hope. Melissa, we were going to, but before we found this trial. And this trial is live. Donna Adelson's trial is a foregone conclusion here. She's going to be serving life. We can revisit it, but I think we're going to stick with this little one if that's all right. I apologize for the leading you guys astray on that one. Let's see. There are plenty of great content creators that are going to be following the Donna Adelson sentencing. So feel free to poke around a little bit and see who's following that. Canada had the first Thanksgiving. Yay. Columbus discovered something that was already discovered. Yes, apparently the Norwegians, the Vikings, named this land Vinland long before Columbus came over. There's to the victor goes the privilege of writing the history books. That's how it goes. Bank holiday is just an old term. It's a public holiday, but remember that we also call our vacations holidays. You go on holiday, where we go on vacation over here. It's a 2-day trial at the most, says Josh. They're planning to work late. I think I was going to tell you. Okay, Josh, thanks for this, because I just got a text from my local town saying, hey, this is blank from the town. I was checking to see if you're planning on streaming our board meeting tonight. So I will let them know I have a court case that will be running late tonight. There we go. They have enough time to set up a phone on a tripod and they'll be good. All right. It's my excuse for not having to go to my city meeting. It is. My daughter would actually love to go. She loves helping out with those. She can set up almost all the equipment, the PTZ camera, the tripods, plugging things in, microphones. She's phenomenal. She's like my best helper. All right. Let's take a lunch. I know my lunch is almost done. I've got a little bit of lettuce to eat and a little bit, I think 3 croutons and 2 pieces of, I don't know what this is called, like grilled chicken, like fajita chicken is what I put on top of it. I missed your milestone. Josh, I apologize. Let me go back and see if I can find it here. Lainey Sue, 8 months. Congratulations. PJ Wolf Weemers, OG. Thank you. 25 months. Selena K, 30 months as an attorney. OG. Laura Fry, member for 15 months. Queen Olive, 33 months. Another OG. Rose with Thorns, 14 months. Kelly Hicks, welcome to the gallery. Josh Hutchins, member for 20 months. Josh, that makes you an OG. And also attorney level support. Almost 2 years officially. Love it here, especially my fellow mods, even though they file motions against my objection. Yes, they do. Red Pen, member for 33 months. OG. Josh didn't like my ideas. Yeah. It's a little battle of the motions this morning. Cody Height, member for 5 months. A goatee beard is a bib. Okay, I'm going to comb mine over lunch. That's what I'm going to do, get the lettuce out of it. Breezy B, welcome. Breezy Bree, welcome to the gallery. Hannah, member for 23 months. Last month in orange, but you've been an OG for several months. OG. And Isla for me, welcome to the gallery. Anna says, do you think Wendy Adelson will be arrested this week? I was surprised it's taken this long. I thought there was going to be action before this, especially with the questions that they asked during the Adelson trial, during Donna's trial, where they basically were prosecuting Wendy for a large portion of it. I'm surprised they haven't gone forward yet. But maybe once this is out of the way, they will. Sloth Life member for 21 months, OG. Your sparkling wit and charm. Yes, it's the best place, keeps you sane. Thank you. Thank you, Sloth Life. Hope you're doing well. Libby, member for 23 months. Happy Indigenous Peoples Day. Happy Indigenous Peoples Day to you as well. You're clearly in a place that celebrates that. Aunt Karen, member for 25 months. OG, love my RA family. Thank you very much, Aunt Karen, as well. All right. With the short break, we have we're only going to have about half an hour of break to get some lunch. Let's do a portal. I will get that set up so we can come back to this trial. Give me just a second here. We're going to name this. Oh, why did I call this Daisy Link Part 4? Oops. So this is the only fan to Contra-ban trial.
I don't like podiums, Your
is Contra-ban hyphenated? Okay. Let's see. And this is, let me just go back to main screen. This is Ohio versus Thornton Thomas. I think Mr. Thomas has a chance of winning this one. I really, really do. And I think the jury's going to be pretty upset with the jail if things continue the way it has. So part 2 will start after lunch. We're going to come in at, let's see, 1:25. Does that work? That gives us 5 minutes heads up before court starts. And we'll be back. Portal is built. All right. There we go. I need to order a few more things for Halloween. I forgot. I have not ordered the white investigation, the crime scene suits. I've got to get those. I've decided I don't think I'm going to get the fog machine. I think that's just overdoing it a little bit. You know, crime scene, fog machine. They just didn't fit well together. Okay, hang on. Edit. Copy. Cancel back. This one. We're renaming this stream right here to be part 1. Okay. And then we'll build the portal. There we go. I'm rethinking it. Yes, I've been rethinking all this. We've got 600 bags of candy prepared, ready to give away already. And very, very little has been consumed by us. Like I've had one candy bar, one little white chocolate cookies and cream Hershey's candy bar. Your feelings are hurt. Don't have your feelings hurt. What are they hurt for? I ignored your milestone. I didn't see it in the list. Oh, it hadn't come up yet. It just barely popped up right as I was leaving. Bite Me says, I'm still here. Love it. The best place to hang out. Love y'all. 33 months. OG. Thank you, Rebecca. Sorry, that came up right at the tail end after I had scrolled to the bottom, but before I had switched back. All right. I've got a lightning machine. Oh, like a Van de Graaff generator. Could do that. I've built one of those before. Yeah, a great willpower. Mostly I just say it's company. It's because we're live streaming this. It's business stuff. You can't eat it. It belongs to the company. So, all right, let's go to lunch. Take a quick break. I'm going to check in with Mrs. R.A., see how things are going on the homeschool front this morning. We're going to come back and follow this case, which is intriguing. I think it should have a lot more attention than it does. If the allegations that the defense are trying to bring to light are true, this should spark some changes instead of some retribution. So, lots of pecans for giving out instead of candy. Our pecans are not good, apparently. All right, tonight when you go home, please hug the people you love. Smile at someone, make their day just a little bit better. And please stay safe to go live again in 30 minutes. 30 minutes we'll be live. Portal set up. You can portal over and continue talking with everybody when you jump there. When you land, we'd love it if you like the stream. It's also good if you like this one before you leave. But you know what to do. Thank you very much. You guys, see you after lunch. Have a good one.
I'm trying to have court. I'm raising voices.
What more do you need to see?
There's nothing in the order that restrains you from talking to cats. I was kicked back, taking it easy. I saw a chicken fight.
Hang on, I can't portal yet because I'm checking a naughty list really quickly. Just 1 second.
Happy birthday. You look good.
Hang on, we're going to portal in just a second, guys. It's not broken.
The zombie apocalypse may be upon us.
Because he's the guy.
I'm not a cat.
You're talking about stuff that is not relevant.